The justices of the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business to speak before this court will be brought here, give their attendance, and they shall be heard.
Good see everybody. Okay, good morning. Thank you for braving the cold to be here. We'll start off our calendar. Number 99 is submitted. Case number 100, the People versus Kenneth Nixon.
Morning, Your Honors. Kathy Reardon for Kenneth Nixon. Your Honors, with regards to the waiver of appeal, we've raised several issues. Just in addressing one of them, which would be that we're asking this court to follow the Second Department's case in Sutton. This was a court offer. The court unilaterally imposed a waiver of appeal, which, by the way, the defendant didn't hear anything about until just after the Boykin rights.
Counsel, if we could focus in on that for just a minute here. As I read the record, there is an offer by the court, which the people vigorously opposed
Right.
for interim probation. And the court says very clearly, this is what I'm offering. I'm going to give you 2 weeks and come back. And you got to let me know if you're going to take it or not.
Correct.
And then the defendant comes back in 2 weeks and the court repeats the offer at the outset. And it's not until the court's actually taking the plea that there's any reference to a waiver of the right of appeal. Is that correct?
That's correct, Your Honor. So there's no notification at all until after, again, the court goes through the Boykin rights and says, and now we're going to do a waiver of appeal. And there's no indication that there was any discussion, obviously, between counsel and Mr. Nixon, that there was discussion regarding this waiver of appeal. The court certainly didn't say anything.
But if your client then waives his rights, what does he get? What does he get by waiving his rights at that juncture in the proceeding?
He doesn't really get anything.
He gets nothing.
Right.
Right.
And that's the issue, and that's the problem.
That's really the underlying issue. Not that the court didn't make some kind of articulation as to why I'm asking you to waive your rights, but as I understand your brief is the deal was fully negotiated, and then all of a sudden, at the very last minute, there's this request to waive your right.
That's exactly correct.
And we have a little bit of a legal problem here because our court has said that they are not adopting such. But there's a step between Sutton and, there's one step further back. And that would be, Sutton requires an elucidation of what you're getting in exchange. I mean, can we just look at the actual deal and make that decision ourselves without the court elucidation? Isn't there that other place we can get to?
I don't think so, Your Honor, because I think the client still has to understand what it is that he's receiving and what it is that he's waiving. And there's no indication on this record that he was aware of any of that. So I think in a situation such as this, where it comes up basically, out of the air right before he's going through the colloquy, that it's just not enough to hold him to this waiver of his appeal. It's my understanding as well that the Court of Appeals may be taking this issue maybe in the spring. So
That would be nice. That would be helpful. Let's put it that way for all.
that's
Yeah.
my
Well,
understanding.
I mean, I guess the problem I'm having is that if you're looking at this in respect, that he was charged with a couple C felonies or C felony, D felony, he was charged with, shooting at an officer twice, right? And the judge then offers this individual who's done that, is charged with interim probation.
Correct.
Do what the conditions are for interim probation. Do so, and then I will give you YO and you'll have probation,
Right.
contrary to the original charges. So was your client going to say, well, wait a minute, this is something new. This waiver of appeal that you're throwing at me right now, I need to consider that. I may not take this deal.
Well, I think actually he could say that, Your Honor, there's kind of two issues there.
Would he really,
But-
he has to be practical.
But I mean, and I guess practically, the reason I suppose that the court offered this was
I
based.
don't know any reason why.
Well, and we don't,
You're,
and that's,
you're
and
supposing now.
that's the problem. But the. court
Maybe,
makes-
maybe then if we're supposing then, maybe during the conferences before, maybe the judge said that, waiver of appeal is part of this as well.
But there's no, but that doesn't show up anywhere on the record that the court made that indication to Mr. Nixon.
he was aware of this deal. He was, and he spoke to his attorney about waiving the right to appeal. And you're willing to do so in exchange for the plea and the sentence agreement in this matter. Yes, I'm going to do so. This is a fantastic deal. It's very favorable to me. I have an opportunity to be YO and not have this conviction follow me around. All I have to do is follow these conditions.
Well, a couple of things here. And one, I'll get to that in a minute, but we don't know that in fact he was ever informed of any of those conditions. And I think that's in actually part 3 of my brief, that there's nothing to indicate that he was ever provided the conditions.
But he does acknowledge later on, he says, yes, I'm aware I violated those conditions.
Well, again, I think, there's a requirement under 39030 that he be provided, that he receive a copy of those conditions. And there's nothing in this record
So
that
let's
establishes.
this and go back. So he goes to trial again and faces the felonies again, which he's already has.
Well, I think we're asking that the case go back. And again, and you're correct. We don't know what the basis was, but the court has indicated that there was a question here. Yes, he fired this weapon towards the police. The police also indicated that they saw him running, and he told the police, we were running. I fired because all I saw was a black unmarked car. So he had no idea that in fact it was the police, because they didn't identify themselves at that point. He could just have thought this
Does
is.
it make a difference that he fired at the police or fired at an individual who's chasing? Does it make a difference?
And that's, well, I mean, if he's running because there's a drive-by, I'm not giving him credit for shooting, but I guess the point being that he was trying to escape this drive-by and he fires because there's an unmarked car sitting there, and that's what he was concerned with. So, is that the basis of this offer? Maybe it is, because, and it also indicate, this went to the grand jury. Grand jury had other options and they didn't charge him with those options. So they charged him with the CPW, and the menacing.
With respect to the third issue, we can go back to that for a second. I realize we're jumping around a little. And the fact that he didn't sign the list of the conditions.
Right.
I mean, he did meet with probation a few times, several times. In fact, just the last one was the only missed appearance that we're aware of.
Right.
So it's presumed that he had some discussion with probation, really because he doesn't make the argument later that he didn't. I wasn't aware of the conditions.
Well,
One question I have though is, was he aware of the ramifications of violating the conditions? Because I thought it was important that in the report that was sent to the court, there wasn't a recommendation that you violate it. It was a recommendation that we add a GPS monitor.
correct.
And so if that was the same communication that was given to the defendant when he was at the grandfather's house and he had him on the phone and he said, hey, where are you? You better come back. If the probation officer had said to him, if you don't do this, I'm going to put a GPS ankle monitor on you, or I'm going to ask the court to do that,
Right.
which is what he ultimately did.
Right.
The defendant is not able to really weigh what a violation is, what isn't a violation, because he thinks that there's a different ramification, even though they're both violations.
Right. No, and yeah, and I mean, we're starting from the point where we don't even think we get to that point, because there's no indication that he was ever provided with them at the time that interim probation was placed upon him, as we know, because it's in the record. There's no indication that he was ever presented with these. He didn't sign them, because in the record, you can see that the only one who ever signed them was the judge. So, I mean, that alone, I think, is sufficient. And there are cases that I raised in my brief about, due process. How do you find somebody violated these conditions when there's no proof that he knew about them in the first place? But then, to your point, I think that's also important, that, how does he know what the alternatives were if nobody ever said anything to him? And I mean, the probation officer, turned to the court and said, let's put him on a GPS monitor. The kid missed 2 curfews and 1 meeting. And he's done some of these other things, and the court went straight, and I know I'm jumping straight ahead here, but the court went straight to, I'm going to sentence you to 5 years, which, by the way, there's some discrepancies in this record as to exactly what the sentence promise was. Initially, it was a maximum, if you didn't follow through, a maximum of 5 years. Defense counsel says, well, wait a second, earlier you had said maximum, now you're saying that is, in fact, the sentence. So there's discrepancy right through to the end, exactly what he was totally facing here in any event. So
Okay,
I think I've covered everything at this point.
thank you,
Thank
counsel.
you.
Please, the court, Bridget Field on behalf of the people. With regard to the waiver of appeal, this court has rejected the holding in Sutton, and I believe this court should follow its prior decisions in that regard.
Okay, so Sutton said that the court had to elucidate its reasons, for imposing the waiver.
Right.
Can't we just look at the circumstances and decide for ourselves whether or not there was a reason for the waiver or any consideration for the waiver without the necessity of the oral elucidation on the record?
I wouldn't disagree with that.
Okay. All right.
And I feel that this record bears out a reason for the waiver of appeal. This was an extraordinary offer from the court. It was an offer for the potential for the defendant to receive WIO sentencing or a WIO adjudication on a weapons possession charge.
Yeah, and I think we'll all agree with you. It was a fabulous outcome, but the question is, was the waiver of appeal one of those pieces of the pie that made it happen, or did that come later, I guess is our question. Was it one of the negotiation points?
I would defer to the record as the court has clearly laid out. Obviously, we can only look at what was said in the record in this case. But I do believe that the defendant was certainly free to ask questions. The court was very clear during its plea colloquy and its explanation of the waiver of appeal. The defendant indicated that he understood what was being said, didn't question why any of this was being made part of the plea deal or the negotiation. So I think that in looking at this, we have to also look at all of the things that were said during the plea colloquy and the very clear and separate colloquy regarding the waiver of appeal rights, which included that this was separate than, the plea portion and all of the correct things under the model colloquy. I apologize, my voice is fading.
Again, there was no objection by the defendant to this introduction at that point in time as it was going forward, correct?
Correct. And he was represented by seasoned counsel who certainly had the ability to pause the proceedings, ask for a pause, or speak to his client at any point during these proceedings. And none of that took place during the colloquy in this case.
I don't see any claim in appellant's brief with respect to there was no consideration for this. So it was never brought up below.
Correct. And there was no allegation of ineffective assistance of counsel for defense counsel letting this go forward. So that's another component that I believe needs to be looked at in considering whether it was appropriate to go forward with this waiver of appeal. And then moving to the
What about the conditions? Apparently there was the conditions that
that was where I was going and lost my thought. I apologize.
no signature of the defendant on these conditions.
So, but defendant didn't complain of the conditions. And I believe that Judge Dallinger, and again, I would defer to the record, but I believe that Judge Dallinger, when he made this offer, said, I'm going to hold you to this. And if you don't meet the conditions, if you violate the conditions, there could be a different outcome than youthful offender.
That was said at a time when we didn't know what the conditions were. there was these hypothetical conditions that are coming soon to a probation meeting near you. But what we had here in terms of when it was set forth, we had June 29th. He's appearing June 29th to 22. He's appearing in front of the court, agrees to the interim probation that there's going to be conditions coming. Meet with your probation officer today. Oh, I might not get there today. Judge, can you go tomorrow morning? Sure, go tomorrow morning. So goes to see probation. We don't know because probation never testified, but you assume June 29th, June 30th. The conditions are dated by the judge, July 6th. So we know that whenever he went to see probation for the first meeting, they didn't have the conditions yet at the first meeting either. Now, I appreciate that later on, down the road, when he finally comes in with his attorney, which again, his attorney wasn't there at first. Now we're at the end of July, August. The attorney never said, gee, judge, he never got any of the conditions. That wasn't raised. So assuming that he got the conditions at some point, but what was the meaning like? What did they talk about? What were the ramifications for violating? Was it, you're going to jail for 5 years, or we're going to put an ankle bracelet on you? And what was his understanding? And that was never done because we had this summary hearing in August where the judge just said, I told you to make sure you followed them, and now you're done.
Let me try and address everything. First of all, that's okay. Admittedly, the judge did not sign the conditions until July 6th of 2022. All of the violations that were alleged took place after July 6th, 2022. Defense counsel at no time argued that when the defendant met with probation that he wasn't given terms of probation, and these weren't obscure terms either. Defendant wasn't home after following a curfew, and not only was he not home, he refused to tell probation where he was. These are very, very general terms of probation. These weren't something specific or unique to this case that there really is any chance that probation wouldn't have advised him of. Of course, probation didn't testify, but defense counsel didn't raise those issues. I'm sorry, I didn't mean to talk over you.
No, it's okay. I was going to ask a helpful question. The conditions don't just say you can't miss curfew. It also says must truthfully answer all reasonable inquiries by the probation officer. It's the third condition.
Correct.
So.
Correct. And he was, if not lying to his probation officer, he was hiding his whereabouts. Obviously, a very significant concern for a young person who had been convicted of being in possession of a weapon and had actually shot that weapon, whatever the circumstances were. This was a very concerning case with the potential for a very, very good outcome. It's not surprising that the judge was going to hold him, very strictly to the terms of probation and to any violations of probation in this case. So I think that unless the court has any other questions, we would ask that the conviction be affirmed.
Thank you, counsel.
Thank you.
Okay. Case number 101 is submitted. Case number 102, People versus George Everson. We have Mr. Keene by video. Mr. Keene, good morning.
Good morning. May it please the court, Brad Keene for Mr. Everson. We assert that new sentencing proceedings should be had for two reasons. Either a lack of meaningful representation or a failure by the trial court to order replacement counsel. Defense counsel failed to protect George's rights at sentencing in really standing mute. He didn't advocate for a particular sentence and then didn't respond when the trial court criticized George for failing to make a motion to withdraw his guilty plea. But he was represented at that time. So it wouldn't be expected and the trial court could refuse to even consider a pro se motion. Relatedly, if the court doesn't find that constitutes ineffective assistance of counsel, it should have ordered replacement counsel. So Mr. Everson didn't explicitly request replacement counsel. But when defense counsel said, he said that he called him out. He said that he was going to, he basically sold him down the river. So something, I forget exactly what Everson
He
said.
sold him out.
Yeah, sold him out. Thank you, Your Honor. When he said that, it's like defense counsel just gave up, and constructively that should have led the trial court to further inquiry as to whether replacement counsel was appropriate. And under those circumstances, understanding that he didn't actually make the request, the trial court still should have done further inquiry, and we would ask for new sentencing proceedings. Unless the court has questions about the mistrial point, which is detailed in the brief, or any of the other issues that I raised, then I'll rely on the brief.
Great. We'll look at it very carefully. Thank you.
Good morning, Your Honors. Elizabeth Dannon for the people. We would start out with respect to the sentencing question there, that this is waived by defendant's valid waiver of appeal. Additionally, the court's duty to make an inquiry into whether substitution of counsel is needed is only triggered when the defendant joins in a request. Here, neither defense counsel nor defendant requested substitution of counsel at sentencing. And in addition, I would note that the cases that defendant cites in support of his contention where substitute counsel was determined to be needed at counsel were in cases where the counsel was newly appointed and knew nothing about the case.
And that's not what we have here.
That is not what we have here, Your Honor.
Okay. Thank you, counsel.
Thank you.
Case number 103, People versus Chandler Dow.
It'd be me as well, Your Honor.
And counsel submits.
Oh, I did not know that.
Yes.
In that case, I will just rely on my papers as well.
Thank you very much. Case number 104, People versus Louis Serrano.
Good morning, Your Honor.
Morning.
May it please the court, counsel. Attorney Michael Whitmer, I'm here for Louis Serrano on appeal. This is a plea case to 3 counts of CPW. The main issue in the case, I think, is from reading my brief, reading counsel's brief, is whether or not it was preserved, this motion for CPL 30.30 based upon subdivision 6. Obviously, it's appellant's position that that was preserved and that the time period is presumptively for dismissal.
Timing is the most important thing, and we should scour the record to make sure we understand what the time frame was. Is that right?
Yes. No, I agree. I think that there's certainly from the prosecution standpoint, I think there is an argument for remand also to the trial court to be able to clarify what exactly those dates are, particularly based upon the only thing that's really said about whether or not there's excludable time is the judge in the case says kind of offhand, like, oh, I think that there was excludable time from adjournments from defense counsel on consent. Why I don't think that necessarily this court has to send it back for a remand is it's dispelled by the record. Essentially is that there's nothing in the record that says that these adjournments are at defense counsel's request.
Counsel, I'm even thinking of different timeframes that we're not looking at those timeframes, but when certain decisions were made by the court. Okay, that I think is really more important than almost the merits that you're speaking about.
Understood. So basically, this case begins with the filing of a felony complaint, and that commences the case in September 22nd, 2021. September 30th, it's waived to the grand jury. when they failed to go forward for the PH. On May.
I'm thinking differently.
Oh,
Okay.
okay.
Let's move forward to, the plea, okay, and the timing of the plea and did that come before or after the court made decisions with regard to the suppression issue?
Okay, so I understand now. So very clearly, the motions were made, at the very least, the defendant made a pro se 180.85 motion long before. Defense counsel made omnibus motions in December of 2023. And in those motions, he obviously raised speedy trial. And it wasn't until sentencing that the court clarified that, yes, I did review those. I did deny that motion.
Okay, but the record doesn't reveal that the court actually denied them beforehand, does it?
That they denied it before the plea?
Yes.
No, it doesn't say that explicitly, but I will say that just from a reading of the statute itself, 30.30 subdivision 6 says an order that is finally denying a motion to dismiss pursuant to subdivision 1 of this section shall be reviewable upon appeal from an ensuing judgment. So, I mean, very clearly the motion was made. There was a final order. It was before the ensuing judgment. It's preserved.
Okay. Thank you. Counsel.
Thank you.
Good morning, Your Honors. Marty McCarthy for the people. The judge did this. He didn't deny this. He didn't deny the motion. He didn't decide the motion. There's no evidence in the record that he did. To say so after the fact, to say so after the plea, once the plea happens, you have abandoned your claims of any undecided motions at that point, which is what occurred in this case. And you also have to look at the motion itself. The time period in the motion alleged controls whether the court ought to have denied that motion or not. And when you look at the motion, it doesn't allege a commencement date. You can't scour the record for that because it's the defendant's obligation to allege that. Didn't do that in this
So
case.
even if it's not waived, you're saying that merits are lacking?
Yeah, because there would be no basis for remitting for the court to determine the motion, because when you look at the motion, there's only one time period that the defendant alleged, and it was 182 days in length. And if you accept his representation, the defendant's representation, that the action commenced on September 27th, that would put the 6-month period out to a total 183 days. And even if you didn't credit the Sunday under general construction law, you also have to consider the fact that the statute speaks in terms of excess of 6 months, and 182 days equals 182 days. So in any event, whether you credited the statute, the extra day under general construction law or not, it didn't exceed 6 months. So there'd be no basis to send it back anyway. And no other questions?
Thank you, counsel.
Thank you.
Okay. Cases number 105 and 106, I think have been submitted. Case number 107 and 108. People versus James Moore. We're gonna do the two together, right?
Yes, that'll be my preference, if that's
Yes.
okay with the court.
Good.
Thank you, Your Honors.
Yes, that was our intention. Yes.
Great, thank you, Your Honor. Good morning, Your Honors. May it please the court, Guy Talia on behalf of defendant appellant James Moore. And I would like to begin, there are two separate appeals, as you just noted. They have discrete issues, but there is an issue that overlaps in both, and I'd like to begin with that, which is the ineffective assistance of counsel for failing to timely make a meritorious 3030 motion to dismiss the indictment for a speedy trial violation. It is well settled that the failure of counsel to assert a meritorious statutory speedy trial violation on its own can be an egregious error to render representation ineffective.
And it looks like in reviewing the transcript that the court didn't decide it because it was untimely. It was untimely, but that wasn't the basis. That the court essentially tried to rule on the merits. Is that your understanding as well?
Yes, that is our understanding, Your Honor. That's correct.
So why does it matter that it was untimely if that wasn't the basis for the denial anyway?
Well, Your Honor, I think the fact that it was ultimately made and not dismissed out of hand because it was untimely. You can review it either as ineffective assistance of counsel, because if it had been granted, it surely would have been reversed on appeal if the people when the people caught the error. But in any event, we can just view the issue in that respect as the court erred in denying the motion, and we can just kind of look to the merits, which would be the same analysis on an ineffective assistance of counsel claim. You would determine on the record whether we can determine whether the motion was meritorious or not, which we argue we can do here. The record is sufficient to make that determination. So whether it's ineffective assistance of counsel, or if you want to treat the argument as the trial court simply erred in denying the motion, it's kind of the same analysis, I believe. So
You don't believe you need to have a separate point in the brief that says that the court got it wrong, got the ruling wrong?
well, I mean, I think
As opposed to being untimely or ineffective counsel.
I don't know that it needs to be specifically a separate point. I mean, the brief certainly goes through the reasons why the denial of the motion was incorrect. And I think that's kind of the thrust of what is set forth in the briefing, and the response as well, argues the merits of the motion. So I would submit that even though it wasn't a separate point heading, that was the thrust of the brief. It was written in the context of ineffective assistance of counsel, but the point is the same. The court erred in denying the motion. So turning to that point, whether the record is sufficient here to determine whether the motion was meritorious or not, we believe there's several reasons why the record demonstrates the motion should have been granted. First, as Justice Novak just pointed out, the motion was actually made, and the court did attempt to rule on it. So when the motion was made, that triggered the people's obligation and indeed their burden to, explain the delay. There was a delay that was presented a prima facie case that exceeded the time. So they were required to explain their due diligence or reasonable inquiry, or if not, a reasonable excuse for the delay. They did neither of those things. They had an opportunity, albeit short, and then they had oral argument the next day. They could have asked for more time and they didn't, but the only response they gave was kind of a misleading response that the issue had already been ruled upon by Justice Renzi, which it clearly was not. Justice Renzi kind of tangentially addressed the issue at an oral kind of motion, but what he ruled basically was that a prejudice standard, like that the failure to disclose the warrants, was irrelevant to trial because they weren't planning on introducing it. But as the subsequent motion before Justice Walsh pointed out, prejudice has nothing to do with the inquiry. It was clearly automatic discovery. It was in the people's possession.
If we agree with you and we find that the issue is preserved and that the argument is made in the brief, what's the remedy? Do we send this back for just a hearing, a 30-30 hearing with new counsel? Does it vacate the entire conviction? What are you claiming? That may be part of the problem with it not being a separate heading in the brief. We don't know what you're asking.
Sure, I can definitely answer that, Your Honor. So in the first instance, the remedy that we would be seeking is dismissal of the indictments, because we believe that people are raising issues for the first time on appeal here in terms of the excludable time, and we shouldn't even be considering those. They had their opportunity, they didn't respond. The motion, the delay was evident based upon the lack of due diligence or reasonable inquiry, and we believe that there's no excludable delay anyway, as set forth in our brief. So the remedy there would be dismissal of the indictment. That would cover both appeals. Alternatively, Your Honor, if this court deems that maybe the people didn't have an opportunity to respond properly or the record is insufficient, the remedy would be exactly that: remittal for a new hearing on the 30-30 motion. So that would be what we were requesting in terms of the remedy for this error. Either just outright dismissal for the reasons I've just explained, or a remittal for a new hearing on the 30-30 issue, where if the court deems that people didn't have opportunity to respond, they can present their arguments.
Counsel, what if we concluded counsel was ineffective? What would be the remedy there?
I think it would be the same thing. If it's ineffective assistance of counsel, our argument is that the record is sufficient to determine that the motion should have been granted, and that would be outright dismissal. But if this court again concludes that you can't determine that from the record, even on an ineffective assistance of counsel claim, the remedy would be remittal to have a new hearing.
If we agree with you, counsel didn't make it timely, then the remedy is remittal.
Yeah, I think that would be, well, again, our first remedy is dismissal, but I think that if you agree that it wasn't timely made and it's viewed in the context of an ineffective assistance of counsel claim, I believe the court can say, the analysis is to review the record to see whether this court can determine if it shouldn't have been granted. And I think if this court is not able to conclude that and feels that either the people need a more opportunity to respond or the record's insufficient, then it still would be a remittal for a new hearing, even in an ineffective assistance of counsel context.
Can you address the issue about the suppression of the physical evidence?
Yes, Your Honor, I can do that. So we're talking about the second appeal, the CPW case. So the issue there seems to be whether the defendant was under arrest at the time that the warrantless search was conducted in the probation offices. There was conclusory testimony that he was under arrest, but if you view the body worn footage, it's clear that he was being advised that he was not under arrest, but he's merely being detained for further questioning. No one ever asserted at that point that there was probable cause that he had committed a crime. And he was advised that several different times. He was advised that right when he was being arrested. He was advised that again when he was brought back to the public safety building, and he asked, "Am I under arrest? Am I being charged with a crime?" And the answer was repeatedly no. So
We wanted him to keep talking.
exactly. So I think that he was not under arrest, and so the search cannot be justified as a warrantless search pursuant to search incident to arrest, because they had no probable cause at that time to arrest him, and he was told he wasn't under arrest. So the conclusory statements and the testimony from the investigator, it just should be disregarded because it's just belied by the other record evidence. And so if that search is unlawful, then
That whole
It's
charge
up.
goes away.
yeah, everything else falls because that's how the probation officers got the key. They weren't going to search him in conjunction with probation search at all. If I may, I'd like to just briefly turn to if this court does not dismiss the indictment or order a new hearing on the 3030 motion. There's several reasons why Mr. Moore deserves a new trial. Beginning first, obviously, with Justice Renzi's failure to grant him the opportunity to hire a new counsel when
Is that really what Judge Renzi did?
I believe it is, Your Honor. If you read the record, he offered him three choices. He said you can represent yourself, stay with your current attorney, or get new counsel. And Mr. Moore said, "I would like to get new counsel." And then almost immediately, Justice Renzi said, "Well, I'm not going to let you do that." So he offered it, but it was
He wasn't going to adjourn the trial to allow him to get new counsel and get that new counsel up to speed. But so I guess for your argument to work, that has to be tantamount to denying him new counsel.
That is true, but I think it's a little bit more than that. I think Justice Renzi actually went a little bit further and said, I'm not granting you the adjournment, but he also told his current counsel, "You're on the case. You're not getting new counsel." When they returned a week
But
later,
if he meant, right now, you're still on the case unless he comes in with retained counsel and has no counsel, you're still on the case. That's a little bit different than the way you.
that may be a fair interpretation, but I disagree with
You need us
that's how
to
I
closely
see.
look at that language and see what happens.
I'm sorry?
You need us to closely look at the language of Judge Renzi and to see what happened.
I think so, but even denying the adjournment is probably sufficient to, kind of be a functional denial of his opportunity to hire a new attorney, because really, honestly, 2 weeks is how is he going to hire a new attorney and say, "Oh, by the way, you have to try this case in 2 weeks." That's not going to be able to find anybody to do that for him, quite frankly. So whether it's an outright denial of new counsel or the functional equivalent by denying him the adjournment, I think it's the same problem. Our brief goes through the litany of errors that also would result in a new trial because of additional ineffective assistance of counsel. We've already pointed out the failure to make a timely 3030 motion. There's other errors, doing his summation before the charge conference, not striking a juror who indicated bias against Mr. Moore, who actually ended up on the jury. There's a couple other things I'd like to point out as well. the defense counsel's failure to review the medical records, which resulted in this dispute over the photos that were referenced therein. That was crucially important. If he had gotten those photos, there was very little evidence in this case, other than, the testimony of the complainant. Very little physical evidence, and getting those photos and having an expert review them would have been significant. And an additional error that just kind of came to light was reviewing the medical records that this court requested. They referenced the photos, and it wasn't redacted. They were supposed to be redacted. Defense counsel should have caught that, so that those did not go to the jury as well. I believe that addresses everything. The court has any further questions? Otherwise, I rely on my brief.
Thank you, counsel.
Thank you.
May it please the court, Bridget Field on behalf of the people. I believe that defense counsel raised the argument with regard to the 3030 motion solely in the context of an ineffective assistance of counsel argument. And I believe that that's the only way that this court can look at that issue, because that's the way it was raised, and this court can't create an issue that wasn't raised and we didn't have the opportunity to respond to. And in that vein, this court can consider my arguments or the people's arguments regarding the time calculation, because in order to succeed on an ineffective assistance of counsel argument, counsel would need to establish that the motion was meritorious. In this case, definitely has a difficult procedural history with all the motions being decided by Judge Renzi, the matter being transferred, it appears virtually day of, to Judge Walsh for trial, and then the matter going back to Judge Renzi for all the proceedings on the gun case.
Usually we have a different kind of record where the record says, well, the motion was never made. And so let's analyze, had the motion been made, let's sort of try to figure out whether it would have had merit. Here, the court heard it on the merits, and the people admittedly had little time to submit arguments, but did submit arguments, and those are in the record as well. So we do sort of have a sense of what the arguments were, and they were very different than what was presented in the brief, right?
The people's arguments were very limited, and I think my recollection of the record from that morning is there were quite a number of arguments being made, and the judge went through each of the arguments, and there was no.
It sounds like there were, I don't know, it sounds like I wasn't there, but it reads like that there were three. There were the CPS photos of the apartment.
Yes.
There were the medical photos of
Yes.
the injuries to the victim. And then there was the search warrant and the cell phone. And with respect to the search warrant and the cell phone, it seemed to me that the people's argument was no harm, no foul. We're not going to use it anyway. We didn't disclose it for 8 months, but Judge, we're not going to use it. So don't worry about the 3030. And that's what it sounds like the argument was. Nothing about excludable time. That came later.
At that time, my recollection of the record was there was no argument about excludable time. Also, that the court didn't make any findings with regard to time at all. The court didn't make a time finding with regard to the 3030 motion. So
would it be appropriate, as counsel suggested, to remit to allow that to happen based on maybe the fact that the people had so little time?
My first contention would be that this was not, that the motion wouldn't succeed, and under an ineffective assistance of counsel argument, I've established that the motion wouldn't succeed, so it would not need to go back. If this court would disagree with me, then I would absolutely agree that it would need to be remanded for an appropriate 3030 hearing, because if in fact this court would find that it was ineffective assistance counsel for the manner in which this motion was brought or the timing of the motion, then we should have the opportunity to respond, and the court have the opportunity to clearly lay out its decision on the motion. With regard to some of the other claims of ineffective assistance, well, actually, first with the argument about substitute counsel. This was a retained case. Defense counsel was retained. So the defendant didn't need to go to court to ask the judge for permission to obtain new counsel. So essentially, defendant came to court and said, I'd like an adjournment so I can get new counsel. But this wasn't the case of assigned counsel where it needed the court's permission, where the defendant, I didn't mean to say it, where the defendant needed the court's permission to go out and get new counsel.
And there is a difference between denying new counsel and denying an adjournment.
Correct. We don't know what would have happened had new counsel come in and set forth clearly on the record, the hardship it would have been to go forward to trial if that in fact would have been the case with new counsel. And I don't believe, I agree with Judge Smith that in this case, Judge Renzi's comments to defense counsel were that he was on the case until new counsel appeared, not that he was counsel until he wasn't, essentially, which is typical in any case, that you just don't let counsel out where there isn't new counsel, certainly 2 weeks prior to trial. With regard to the juror issue, I could not possibly go through what I laid out in my brief. I would rely on my brief for the comments that had been made. I believe that the manner in which the initial questioning of this juror was clearly set out that this was an appropriate juror. It's also, it can only be raised as ineffective assistance of counsel because peremptories hadn't been utilized, he hadn't utilized all his peremptories, so it can't be raised as a standalone issue because it would not be a preserved issue. But it's clear throughout this record that Mr. Moore wasn't shy about speaking up in court. So and had the opportunity to discuss with counsel. There's clear breaks where defense counsel and his client were permitted to go into the jury room or permitted to go in quiet to discuss jurors before peremptories were made. So I think it's clear on the record that this was a choice that was consented to by the defendant as well.
Tell us about the second appeal.
The
possession.
the weight issue, correct.
Possession of a weapon.
Yes.
The validity of the search.
I believe that the search was valid. The testimony at the hearing indicated that that defendant had been questioned by CPS worker and then by police, and probation was involved as well. There were basically a lot of people were involved. Investigator Pankaitis said that he was under arrest. The CPS worker said that he was being held when she was done. And there is body-worn camera footage that has been submitted. Officer Castronici's body-worn video, I believe, of him taking Mr. Moore into custody. But it's clear he's being taken into custody. He's handcuffed. He's not free to leave. So I believe that the video, in conjunction with the testimony at trial or at the hearing, were more than sufficient to establish that Mr. Moore was in custody prior to the time that his keys were obtained and taken by the probation department.
So it's your position that this was a valid search incident to arrest?
Yes.
Okay. Thank you.
If there are no further questions, I would rest on my briefs for any following issues.
I think we're all set.
Thank you. Have a good day.
Okay, case number 109, New York State Police versus Matthew Gallagher, and both counsel are virtual. Okay, we have both counsel. Can you both hear us?
Yes, Your Honor.
Yes, Your Honor. Thank you.
Very good. Why don't we proceed?
May it please the court, Sarah Coco for the New York State Police. The court below erred in concluding that Gallagher's participation in the fatal beating of Robert Brooks did not establish a likelihood of future dangerousness such that an ERPO should be entered. And Supreme Court here properly recognized that Gallagher did engage with others in violent conduct that caused serious physical harm, but the court nonetheless denied the ERPO for two legally insufficient reasons, and that's what we're asking this court to review. So the first is that Gallagher's conduct, the Supreme Court concluded that Gallagher's conduct should be addressed exclusively through a criminal proceeding. And second, Supreme Court concluded that Gallagher's conduct was not sufficient evidence of dangerousness because this violent conduct took place in a correctional facility and was directed towards an incarcerated individual. And neither of those would be legally sufficient reasons for denying an ERPO. Article 63A, the ERPO statute, requires courts to issue an ERPO where there's clear and convincing evidence that an individual is likely to engage in conduct that would result in serious harm. And in making that determination, courts are required to consider any past threat or act of violence. That's one of the factors in CPLR 6342. And that reflects a legislative determination that where an individual has engaged in a past act of violence, that is predictive of whether the individual is likely to engage in violence in the future in any context, not only in the same
So,
context.
counsel, your position that his acquittal does not end the inquiry and that we have to view his actions.
That's correct, Your Honor. So nothing in the ERPO statute indicates that simply because someone has been acquitted of a criminal charge, that means that the ERPO would no longer be necessary or appropriate. And that's because the criminal proceeding is addressing a different question on a different standard of evidence than an ERPO proceeding.
Okay, and we do have some actual video to actually view the actions of defendant in real time as they were happening.
That's correct, Your Honor. So here we have the 4 body-worn camera videos, and Supreme Court reviewed those videos and correctly found that Gallagher did participate in this violence, and Gallagher is now
Yeah, we have the videos as well. We have we have the videos as well and have, spent some time taking a look at those as part of this case.
Yes, Your Honor. So as those videos show, Gallagher is arguing on appeal that he was simply doing his job, and we would strongly dispute that. We think that those videos show that he was participating in this violence. First of all, he had the opportunity to observe these other officers using force that's not the type of force that would be justified. He's standing just a few feet away as officers are punching Brooks in the face and groin, hitting him with a shoe and shoving a cloth into his mouth. So at that point, he's already seen this excessive use of force, and then he chooses to participate. He places his hand on Brooks's chest while another officer continues to hit him. And then he goes and gets the leg shackles. He places the leg shackles on Brooks. Now he contends that Brooks was kicking at that point, but if you review the videos, I think you'll see that Brooks was in fact unresponsive. He was given a sternum rub at that point and did not respond. That's a move designed to elicit a response unless the individual is unconscious. So we believe Supreme Court correctly interpreted the videos, and we're asking this court to review the 2 reasons that Supreme Court gave for nonetheless denying an ERPO. And we think that those are legally invalid reasons. So first, the idea that simply because there's a criminal investigation or proceeding, an ERPO would be inappropriate. That's clearly not the case. The statute itself contemplates that there might be a pending criminal charge or conviction. That's one of the factors in CPL 6342. And that doesn't apply here because it's a pending charge with a weapon, but it shows that the legislature thought that an ERPO might be appropriate, even if there's also a criminal investigation of the same conduct. So that would not be a reason for denying an ERPO. And then the second reason Supreme Court gives is that this conduct took place in the context of a correctional facility, and it was violent conduct directed towards an incarcerated individual. And again, the legislature, when it required courts to look at a past act of violence, didn't say that past act of violence could only be in a particular context in order to be relevant evidence of dangerousness. Any past act of violence is going to be relevant evidence of dangerousness. And we cite cases in our brief where individuals have had ERPOs entered based on a workplace threat or act of violence. And that's true even if the individual no longer works at that workplace, no longer has access to the people that they threatened. It's still relevant evidence of dangerousness. And then second, of course, as we explained in our brief,
Mr. Gallagher was a correctional officer, so he had a heightened duty to protect incarcerated individuals, which makes his conduct in this situation particularly concerning. So we're really asking the court to address this faulty reasoning. Now, if the court were to conclude that the result of Mr. Gallagher's criminal trial were critical information that needed to be taken into account, then I suppose one option would be to vacate, clarify these two legal issues that we've raised, and remand for a new hearing where Mr. Gallagher would be able to bring in that new information that isn't in the record here. But we do think that on this record, there is clear and convincing evidence of dangerousness, and this court should simply enter the ERPO.
Okay, unless there's any questions. Thank you, counsel.
Thank you, Your Honor.
Counsel.
Yes, good morning, Your Honors. Kevin Louierman for Mr. Gallagher. Mr. Gallagher never engaged in an act of violence, Your Honors. A proper view of the video, he was one of the only officers that had his camera on. He was not present for most of what happened. He was out in his van. He came in, he stood in a hallway. There were 7 officers in the medical room. He was not one of the officers. 2 of the officers were supervisors. One was the supervisor of that area of the facility. The other was the supervisor for the whole prison.
So in the video, when we see him move forward, and then the other video, we see the blue hand come in and grab the chest as Mr. Brooks is being beaten. Are you claiming that wasn't him? Was that the wrong guy?
No, Your Honor, I believe you're misinterpreting what he did. So what if, from his vantage point, what had happened was he walked into the room for, there was no physical contact going on. It was inappropriate. And then there was an abrupt 4 seconds of an assault, and then it stopped. Then Mr. Gallagher, then what happened was the officers tried to, very inappropriately, several officers tried to raise Mr. Brooks up off the gurney, and they were using excessive force. They were harming him. Mr. Gallagher's supervisor was standing in front of him. He looks at his supervisor doesn't move. He then steps forward he's not a superior to those officers. He's a co-worker. And what he does, he grabs onto Mr. Brooks's shirt. He pulls him up onto the gurney so the assault would stop. That's all he did. And then he is dispatched to go obtain shackles for Mr. Brooks' ankles. That's what he was dispatched to do. That's the time frame on Mr. Gallagher's conduct is 9/25.
And Counselor, he put the shackles on.
He did, with the assistance of someone else. Yes.
Yeah, he was there and put the shackles on. Are you saying that Judge Rahill got this wrong on the facts?
No. Judge Rahill said at page 2, in describing Mr. Gallagher's conduct, he said, respondent observes other officers strike and one officer kick inmate Brooks. He says that at page 2 in terms of his view of the factual recitation. He doesn't say that Mr. Gallagher engaged in an act of violence. He does not say that. That's the standard under CPLR 6343 subsection 2, an act of violence. He engaged in no act of violence that day. In fact, his pulling Mr. Brooks up, although damage had been done to Mr. Brooks earlier in the night on 2 occasions where Mr. Gallagher wasn't present, and another occasion when Mr. Gallagher was out fetching the shackles from his van, there was violence, none of which Mr. Gallagher knew. Mr. Gallagher's act of pulling Mr. Brooks up onto the gurney momentarily stopped the violence that was going on by the other officers. And then Mr. Gallagher backed away because his supervisor stepped up.
Okay. Well, we have those videos, and we will spend some time with them. Anything else you'd like to say?
No, Your Honor, I would just ask that the video focus part is 9/25/28 to 9/25/44. That's the time period where Mr. Gallagher had any physical contact with Mr. Brooks at that point in time.
With respect, Counsel, one thing you said earlier about how he had turned his camera on, and he was under an obligation because there's a forcible activity. I forget what the standard is, but something happening in the prison that he was supposed to activate the camera. He didn't do that. Nobody did that. Not even the 4 that had their cameras on didn't do that, right?
No, that's correct, Your Honor. But again, Mr. Gallagher wasn't in the room until the activity is happening. He walks in the room, he's in the room, and the violent behavior is a 4-second period. And then it stops. It just stops.
Well.
at that point in time.
Hang on.
And then it resumes later.
Right, and that may be the second question. You're talking about how he was generous in terms of showing with the camera. I noticed that when he went outside in the cold to get the leg shackles, he had his jacket open and we could see what was happening, him getting the shackles from the van. And then when he comes back into the warmth of the facility, he zips the jacket up to cover the camera for 8.5 minutes. And by the time the jacket is zipped down again, Mr. Brooks, the inmate is unconscious and has been stripped down. So we miss a lot in Mr. Gallagher's video, right?
Well, I think there's an assumption that because it's that it's the warmth of the building, it's not a warm building. And regardless of that, there's cameras recording all the activity during that period of time. If not Mr. Gallagher's camera, there's other cameras. Every second is recorded inside that room.
Right. But in terms of giving him credit for keeping his camera on, he really didn't for the 8.5 minutes of the leg shackling work. That wasn't captured on his camera. It was captured on somebody else's.
That's correct, Judge.
Okay, counsel, thank you very much.
Thank you, Your Honor.
Okay, case number 110, Heather J. versus Rochester Regional Health. Okay, we have the counsel that's here by video. So who goes first?
I'm
you.
from Rochester Regional, so I was going to go first.
Yes, go ahead. I know we have two appellants, so that's why I asked who's going to go first. So
Thank you.
you got a seat, counsel.
May it please the court, my name is Haley Buckley from the law firm of Brown, Gradadaro, and Prado, here today representing the appellants Unity Hospital and Rochester Regional Health. Briefly, this matter stems from a labor and delivery of the infant plaintiff Chase Trinello at Unity Hospital on September 5th to September 6th, 2015. Plaintiff mother Heather Johnson elected to undergo a vaginal birth after cesarean section as opposed to a C-section as recommended by her providers on September 5th, 2015. Thereafter, the plaintiff suffered from a uterine rupture, a known risk of proceeding with a vaginal birth after cesarean section. We're here today to appeal the lower court's decision on the appellant's motions for summary judgment. Specifically, there are two claims which the lower court decided remained following our motion for summary judgment by way of order on August 5th, 2024. The first claim that remains is a claim for lack of informed consent as to the Rochester Regional Health defendants. The appellants believe that the court erred as to both law and fact as to this claim. First, it should be noted.
I think we understand that the complaint did not have a separate cause of action for informed consent. Is that right?
That's correct.
And basically it's your position that that's pretty much enough to for us to dispense with that cause of action.
Correct.
Okay.
Now, counsel, what relief are you requesting here?
A dismissal on the lack of informed consent claim and also dismiss.
Just hear me out. Thank you on that. But
Sure.
You're asking us to dismiss an unpled claim?
Yes, Your Honor, because the lower court held that this was a valid claim.
Right. The allegations appear in the amended bill of particulars. That's the first time they appear.
Correct.
And so you bring a motion for summary dismiss claim, but are you really, in some ways, requesting that the plaintiff not be allowed to raise this issue at trial?
Correct. Yeah.
Does dismissing an unpled claim get you that type of relief?
We believe it does. Yes. By dismissing that claim, the plaintiff would be foreclosed from arguing that at trial, especially because there would be no direct claims as remaining to the Rochester Regional Health defendants. The lower court limited the claims that are available for argument at trial, one of which is the informed consent claim, and the other one is as to negligence as to monitoring the fetal monitoring strips. Those are the two things that remain. So anything outside those bounds would be inappropriate to be argued at trial and shouldn't be permitted.
You really don't want any expert proof at trial that there was a failure to advise the plaintiff about the risks of a VBAC.
Correct. And there is no expert proof that was offered in the summary judgment motion as well from plaintiff's counsel. So we agree that it should be dismissed because it was not properly pled, but also it should be dismissed because under public health law section 2805, there specifically has to be an invasion or disruption of the integrity of the body. That was not present here. Vaginal birth after cesarean section is not an invasion or disruption of the body. This is very similar to the cases that have already been decided by this court, specifically the Dunbar versus Women and Children's Hospital, as well as Jaycox versus Reed matters, where the plaintiffs elected to undergo a vaginal birth and did not pursue a C-section was not performed. Similar in this case, the plaintiff is arguing that a C-section was not performed and instead a vaginal birth was allowed to proceed. It's completely comparable to this case, and we believe that it should be dismissed on those grounds. And then further, even if those two reasons were not sufficient enough to not permit a lack of informed consent claim to remain in this case, we believe that we met our prima facie burden by supplying an expert affidavit that showed that we complied with the standard of care, both by way of testimony and by way of the medical records. Plaintiff completely.
Did the plaintiff, meet their burden?
No, they did not. They did not provide any expert affidavit to show that there was any violation of the standard of care by not offering or by not allowing proper informed consent. Certainly, even if it wasn't separately pled, it shouldn't be permitted, that claim should not be permitted to remain because they did not provide any expert proof to support that position, the same way they didn't provide expert proof to the other claims that were then thereafter dismissed by the lower court. And so that is why we believe that those claims should be dismissed. As far as the medical malpractice negligence claims that remain in this case.
One second. Back to the lack of informed consent. I think we all agree that they didn't plead it in their complaint. Right? Okay.
Correct.
And I think it was just referenced in a bill of particulars.
Yes.
Correct? And a bill of particulars, the only purpose is accentuating their claim. Correct?
Yes,
And
Your
I'll
Honor.
agree to that.
Yes.
So if you're now requesting a dismissal of something that didn't exist at the time in the original complaint, you would thereby be prohibiting the plaintiff from exercising their right to amend a complaint at some time.
Yes, Your Honor, because the argument was already made with the lower court and the lower court found that that was a valid claim. And so if they're permitting that to be a valid claim, our argument is that it shouldn't be permitted to be a valid claim to be argued because it wasn't pled, but also because of this other reason, that it is not an invasion of the body and that should not be permitted to be argued and presented to a jury. It would only be confusing and confounding.
I think what Justice Monter is asking, are you preempting a motion to amend the complaint or preempting a motion at the end of the trial to conform the pleadings to the proof?
Yes.
Or in other words, this is like a motion in limine.
Yes.
But it's couched, but it really was a motion for summary judgment to dismiss this unpled complaint.
Yes.
Okay, counsel, thank you.
Thank you. Oh, did you want me to address the negligence claims as well?
Go ahead.
Okay, thank you, Your Honor. So we believe that we met our prima facie burden as to the claims of negligence that the plaintiff is asserting for failing to monitor the plaintiff mother. Yes.
I'm okay with that part, but when you say in terms of meeting the prima facie burden, I noticed that there were three claims that were brought in the complaint and as well as the bill of particulars regarding the first adequately instruct, train, or supervise. Another claim that defendants failed to adopt, follow, and enforce appropriate policies and procedures, and then I don't have the third one. Oh, here it is. Failed to provide appropriately trained and skilled personnel. And it looked from your brief that you referred to Dr. Bertoya's affidavit in terms of saying that's where we met our prima facie burden on it. So I have Dr. Bertoya's affidavit in front of me, and it looks like that was addressed in paragraph 68 through roughly 72. It's 1741 and 1742 of the record. Is this sufficient? Because it looks like Dr. Bertoya for those three claims are just saying, well, they were adequately instructed, trained, or supervised. And this is just boilerplate language. I think she refers to it as boilerplate language a few times, but doesn't explain how they were adequately trained or instructed. She does say that as far as supervision, I supervised them and I did everything appropriate as far as supervision. So I think that she certainly met the claim on that. What about the rest of it?
Yeah, it's our contention that we met those claims and the lower court agreed with us. Furthermore, the plaintiff's attorney did not provide any expert affidavit or proof that dismissed that.
Agreed, no issue of fact. The question is just on the prima facie burden.
Yeah,
That's
we
the
believe that
folks-
we believe that that was sufficient to meet our burden.
All right, and we'll just have to look at the language here on these 2 pages. Is there anywhere else in the record, I guess, that you're pointing to as to how you met the burden other than what I'm looking at?
Well, I think that it's inherent in the fact that you have a medical provider. I'm not sure that the claims were specific enough for us to even really combat, frankly. They're just general claims of lack of supervision. Dr. Bertoya is a licensed medical provider. She says that in the beginning of her affidavit that says she's licensed by New York State, that she is appropriately an attending physician at the hospital that managed her care. Certainly that would be sufficient to show her training and
So that's what all that you are relying on, nothing else.
correct. Yes.
And I mean, belabor the point, but Dr. Bertoya didn't instruct or necessarily trained the traveling nurse. Traveling nurse is the one at issue here, really the primary focus of the plaintiffs.
Sure. Exactly. So the traveling nurse is not our employee. We would have no obligation to instruct or train her anyway. That's certainly not an obligation from Rochester Regional Health standpoint. It wasn't something that has been argued that RN Haskin wasn't properly trained. Certainly her affidavit is sufficient enough to show that she was licensed in New York State and that she is trained. And her testimony said that as well, and in deposition testimony. So we think that would be sufficient to say that anyone who was present in the hospital, who was an employee of Rochester Regional Health, certainly was trained and supervised, and that RN Haskin, by way of her licensure, her testimony, was appropriately trained to be there that day. No one has argued that she's not appropriately trained. I know there's that boilerplate language that says like failed to train or supervise, but there was no specific allegations as to any particular person. There was no, certainly we can't go through every single employee at Rochester Regional Health or Unity Hospital. Literally our affidavit would be pages and pages and pages long, just of names saying that this person received proper training. As far as what negligence claims remain from the lower court's decision, it's failure to monitor the plaintiff's fetal monitoring strips. Specifically, the expert only opines that RN Haskin failed to properly monitor the plaintiff. As already discussed, RN Haskin is not an employee of the hospital. And also, while we disagree with the plaintiff's expert, Dr. Spitalnik, of his findings and these opinions asserted as to they were not asserted as to Rochester Regional Health, but only as to co-defendant RN Haskin. There are no direct claims.
And RN Haskin's relationship to the plaintiff is what? Prior to her entering the hospital and being treated by her?
There was no relationship.
Okay, so they were strangers.
Yes.
So the plaintiff walks into the hospital, is said, here, we'll put you in this room and this person is going to treat you and take care of you. So aren't there some Meduba questions in that scenario?
Certainly there are Meduba questions in that scenario that could be answered by a jury, potentially. But again, our focus really is like these direct claims as to Rochester Regional Health. Perhaps a vicarious liability claim could remain in this case, but as to direct claims as to Rochester Regional Health, there's nothing in that expert affidavit that substantiates those claims. There's no allegations in that expert affidavit that says Rochester Regional Health did something inappropriate or improper.
You're asking that it be limited to, that plaintiff be limited to proving claims relative to the RN, and then whether the RN is subject to Meduba bringing the hospital back in.
Exactly, Your Honor. Yeah, that is exactly what we're alleging in this case. And just lastly, we submit that while respondent in their brief indicates that Dr. Bertoya should have been monitoring or should have been supervising RN Haskin, that was the first time that has been argued and was never stated in their expert affidavit, which would have been necessary. If that was the position of the plaintiff, certainly their expert should have stated in their expert affidavit that the hospital was responsible for monitoring RN Haskin, didn't do so, and therefore this led to this incident. That's not what happened here. It's only in plaintiff's respondent's brief. That is insufficient. Plaintiff's attorney's statements about what should or shouldn't have been done are not sufficient enough. There needs to be expert proof. That is lacking here, and that's why we believe that there should not be any direct claims remaining as to Rochester Regional Health and Unity Hospital.
Thank you, counsel.
Thank you very much.
All right, the counsel on the television goes next, I believe, right?
There is another defendant, Ms. Breyer, so, okay.
That is me. Becky Brett. Ron, may it please the court. I am here on behalf of Nurse Haskin for Rebar Kelly, and I'm substituted in today for Kathleen Kelly Rebar. The focus of our argument here is that it is our contention through the expert affidavit of Nurse Havens, as well as the proof that had been submitted and the deposition testimony in this case, that we have met our prima facie showing of entitlement for summary judgment, thus shifting the burden to plaintiff's counsel.
I have one question about that again, burden. In the brief, it is indicated that the expert provided specific details regarding the efforts made by defendant Haskin to monitor the fetal heart rate. So I went back to the affidavit of the expert, and it doesn't look like the affidavit of the expert says anything that Dr. Haskin did specifically before she noted that and this is from probably about 4:27 or so, when the nurse midwife left, until sometime after 5 a.m. So it's more than a half an hour of time, kind of a critical time period, when and that's after the epidural was in place. And then she noted that she couldn't find the fetal heart rate at that point. It did certain activities, it got it back, lost it again, and then ultimately called for help at 5:17. We have this critical period of 4:27 to 5 o'clock, 5:05 or so in the morning. And I don't see anything in the expert affidavit describing anything that defendant Haskin did during that time period. Do you disagree with that?
Respectfully, I do, Your Honor. We're talking.
You just pointed to me because I missed.
Yes.
She writes on page 975 that the job was to try to monitor the patient as best as she could, and then adjust the monitor to regain contact. So that was generally, but then all we have is paragraph 50 after the epidural was in place. And that's why I'm stuck.
Right, I understand, Your Honor. If you look at paragraph 49, it goes through
A lot about what the patient was doing. Patient went to the bathroom, patient got the epidural. Nothing about Nurse Haskin.
It does talk about, while the patient went to the bathroom, the patient was getting an epidural, and these are real life scenarios in which it is extremely difficult, if not impossible, to get the fetal heart rate tracing. And the reason that that is pointed out is because it is our position that Dr. Spitalnik glossed over the real life happenings during this labor and delivery with Nurse Haskin. Nurse Havens did render an opinion that was extremely specific when she was talking about each step that a patient in labor goes through, from having to, basically there is no monitoring when the patient gets up to go to the bathroom, when the patient gets up to take a walk, when the patient has an epidural or is even just preparing for the epidural. The patient has to be at the end of a bed and sort of in a C position, which makes it virtually impossible to get a fetal heart tracing. Dr. Spitalnik did not address any of those specifics in his affidavit. They're not simply excuses. These events that took place that can be seen in paragraphs 49 and 50 are real life events and standards of care that an obstetrical nurse faces on a daily basis when assisting a mother with labor and delivery. Of course, her obligation was for maternal well-being as well as fetal well-being. And
Counselor, it seems to me that the challenge from the plaintiff's expert here is that the nurse, not that she wasn't competent or qualified to do the task that she was assigned to do, but once there was some red flags, she should have alerted the attending. That's really the essence here of the argument.
So.
And so, but you're the question of whether or not she was competent, because there are things happening, right? The patient had to go to the bathroom, patient needed an epidural. There were other physicians that were attending to this patient at the time. So your position is, as soon as I knew though, however, that there was a problem, I did what I needed to do, and that was call the midwife.
In addition to calling the midwife, the standard of care is first to engage in intrauterine resuscitative measures. And that is something that is incumbent upon the obstetrical nurse. And that is something that she did do to try to get that heart rate back to a point where it was no longer concerning. That is the standard of care. And that is something, quite frankly, had she called the obstetrician in earlier or the midwife in earlier, the question would have been, did you do your resuscitative measures? That was the standard of care. That is not commented on by Dr. Spitana.
Okay, anything further, Counselor?
I have nothing further, Your Honors. Thank you for your time, and I will rely upon the papers.
Thank you very much. Okay, Counsel.
Thank you, Your Honors. I'd like to start with what we just heard, if that's okay, from Ms. Breyer about Nurse Haskins' comments on the Spitalik affidavit. While keeping in mind, of course, that since this is a motion for summary judgment, the defendants have the burden of proof of eliminating material issues of fact from the case while viewing the facts in the light most favorable to the non-moving party. I think that everything we just heard from Ms. Breyer are issues that should be debated in front of a jury. They're issues for a jury's determination because they're disputed factual issues. Dr. Spitalik's affidavit it sufficiently goes through his opinion in this case that it was negligent not to continuously monitor the fetal heart rate, and also says that it was necessary for the nurse to contact the attending earlier than when she did, based on what can be seen from the fetal heart rate tracings. His affidavit specifically identified Nurse Haskin, talks about her acts.
Counsel, let me interrupt you there, because I don't disagree with your reading as it relates to Ms. Haskins or Nurse Haskins, but the hospital defendants say that your expert doesn't make any complaints of the attending or the midwife. The complaint in the affidavit is limited to the nurse. You disagree?
Well, I do disagree, Your Honor, because the affidavit is commenting on what the care team was doing, not just one specific nurse. The doctor present in the hospital is part of the care team. She is ultimately responsible for the care of the patient, and in addition to that,
I don't see the word care team in this affidavit.
It's commenting on what the hospital was doing, what the team at the hospital was doing.
Right.
I don't know if the words care team were used per se, but as part of the care team, the doctor is the one who's ultimately responsible for the patient.
That may be true in reality, but is that in this affidavit? That's what we've got to take a look at.
I think that it is in the affidavit, just as in terms of the general statements being made about the heart rate being monitored. I mean, certainly the doctor still has a duty to keep an eye on the fetal heart rate for her patients. But in any event, it's the hospital that again has the burden of establishing their right to summary judgment on these issues, and they're kind of picking apart which specific people they're responsible for was not something that was in their opening summary judgment motion. And I do want to say that the way that the defendants have continued to move the ball over the course of their initial motion for summary judgment, their reply, their request for reconsideration, and then the appeal, it's really drifted far away from what was in their original motion for summary judgment, which it explains why the expert affidavit is what it is. Because I was responding to the arguments, and the expert was responding to the arguments that they were making in their opening summary judgment briefs and what they proved or what they claim to prove as a prima facie case, right? They're only raising the arguments of who the hospital is responsible for later on. And they're making this argument that they're not responsible for Nurse Haskin and claiming that we're just raising this now. But just to be clear, the complaint specifically says that Nurse Haskin was acting as an agent of the hospital. That's in paragraph 42 of the complaint on page 26 of the record. And it says that the suit is based in part on the acts of the hospital's agents in paragraph 43 on page 27 of the record. The hospital has never said that Nurse Haskin wasn't an actual or apparent agent of the hospital because
And
she
that's
obviously
usually
was.
a question of fact, isn't it, counsel?
It is a question of fact, absolutely.
I think your argument.
Sorry?
I said, I think we have your argument on that.
Okay, all right, that's fine. Do you want to hear more about Nurse Haskin's kind of critiques of Dr. Spitanik's affidavit, or would you like me to move on from that point? I know I was talking.
I'm going to leave that up to you. You tell us what's important
All
to
right,
you.
I'll just say a little bit more about that if that's okay. So Nurse Haskin, there's a real throw everything to the wall and see what sticks approach in her opening appellate brief, raises a multitude of quibbles. Some of them were so clearly off base that she didn't bring them up again in the reply after we pointed out that some of what she was saying was just inaccurate. But she does take issue with the conclusion that the fetal heart rate was hardly monitored at all for these 90 crucial minutes. And Your Honor is right that it is a critical time period here where there's no information in Nurse Haven's affidavit about it. She does say that there was a time when the mother went to the bathroom and got an epidural, but it doesn't take 90 minutes to do those things. And then Ms. Breyer in her argument was just saying that that it takes time for the patient to take a walk. They're just making up additional facts. There was no indication that she did take a walk. So Nurse Haskin's reply also brings up the interventions done by Nurse Haskin, but in a way that it's either we're either talking about things that she did that were too early for it to matter, like adjusting the monitor at 11:30 p.m. the night before, or these intrauterine resuscitative measures, which were at 5:17 a.m., which were too late for it to have any effect. And again, we can debate these issues, but these are really questions of fact for a trial. Nurse Haskin just doesn't like our experts' conclusions about what the standard of care requires here, but that's not the basis for a summary judgment motion. I'll turn over to the informed consent issue here. So again, you heard Ms. Buckley say that she's trying to preempt a motion to amend the complaint and preempt a motion to conform the pleading to the pleadings to the evidence. That's really would be such a unfair victory of form over function here. And it's not just because the theories were in the bill of particulars, but also because we talked about this. We did talk about this during discovery. We talked about it a lot during Dr. Bertoya's deposition. So there definitely is evidence, and they were on notice that we were pursuing evidence about this.
So is there some motion outstanding then to amend and bring in this informed consent claim?
Well, there's not a motion outstanding because at this point, the lower court has just ruled that it was a theory that can be addressed at trial. And that's the ruling that stands at this point. And part of the reason why the court decided that is because the theories were in the bill of particulars and that was sufficient here. I mean, it's part of a larger medical malpractice case. It's acceptable to discuss informed consent theories as part of the bill of particulars. The hospital cites a few cases that they claim.
Counsel, in your view, is lack of informed consent a theory of malpractice, or is it an independent cause of action?
In my view, it is a theory of malpractice, and there's some cases cited in our opposition brief which do say that informed consent can be an element of a medical malpractice claim. That's the Twitchell v. McKay case and the Gray v. Williams case make that comment. In addition, actually, one of the cases cited in the hospital's reply, which is Haga v. Pike, also says, first of all, it doesn't say anything about that to suggest that informed consent has to be pled separately from the medical malpractice claim. It instead says that because the informed consent claims are consistent with the plaintiff's existing theories sounding in negligence and medical malpractice, it won't result in prejudice or surprise to add that. So in other words, these issues are sufficiently intertwined that it's not really a separate theory.
Well, but in cases that we've seen where maybe they do a little bit of discovery, they have some depositions, and then a plaintiff says, well, gee, I'm going to add an informed consent claim, make a motion to amend the complaint. In cases we've seen, there's a requirement that there be an expert affirmation submitted saying with certainty that the defendants prove that the information that the defendants gave that was a departure from what a reasonable practitioner would have disclosed. You need that sort of expert element saying, yeah, this deviated from the standard of care with respect to informed consent. I don't see that you've done that.
Well, Your Honor, and again, where things stand with the lower court is that the Supreme Court has ruled that informed consent is a valid theory to address at trial. If this court feels otherwise, then I would like the opportunity to file that motion and support it with an expert affidavit, which I think will be forthcoming.
Because if you backdoor it, you don't need the expert affidavit.
Understood. I understand, Your Honor, and I would like the opportunity to make that motion if this court finds that the claim has not been sufficiently pled. But again,
and counsel, that would be a post note of issue motion to amend the complaint.
It would, but it would also, I think that's consistent with the ability to file a motion to conform the pleading to the evidence, which can be done before or even after judgment. Right. So I do think that it's been sufficiently pled here. It's part of the larger medical malpractice claim. It's part of the bill of particulars. The hospital hasn't cited one case where the informed consent claim was dismissed, even if it was included within the bill of particulars. All the cases that they're citing, the informed consent claim was outside of the bill of particulars. And there's even one case that was cited in our brief, Paris v. Shankman, where it says that the part of the reason for dismissing the informed consent claim was that the bill of particulars did not mention the theory, which suggests that if the bill of particulars had provided notice, it would have been acceptable. There might have been a different outcome. Now, unless there are any further questions about the pleading issue, I want to move on to the affirmative violation of physical integrity issue that you heard Ms. Buckley talk about. The hospital, so we argued that this issue is unpreserved for appeal, and we stand by that. It wasn't addressed at all in the lower court briefing. And I wanted to note, we cited this case, Sabine v. State, for the proposition that issues not raised below are not preserved for appeal. That was a 2024 Court of Appeals decision. The hospital brought up this Tallaro v. Tallaro decision from 1969, and I thought it was interesting. The Sabine case actually mentions the Tallaro v. Tallaro case and describes it as a rarely used exception to the preservation rule, noting that the Court of Appeals has rarely applied the Tallaro case and not once in the last 4 decades. So clearly, these days, the Court of Appeals doesn't think much of this limited exception to the requirement that you have to actually preserve issues for appeal. But even if this issue was preserved for appeal, it's important to keep in mind that the trial of labor that the hospital needed consent for was in the context of a procedure that they were actually doing, because the mom was only in labor because of the induction, because of the Pitocin that they were injecting into her veins. That is a procedure. And I also want to note in their reply brief, the hospital claims that we didn't allege in the complaint that Pitocin was utilized in a negligent manner, but that's actually just completely wrong based on the text of the complaint. If you look at page 27 of the record, you can see that the allegations do allege that Rochester Regional Health failed to appropriately administer and or manage the Pitocin induction. So it has been part of the case since day one. As to the more of the substantive issues on informed consent, the hospital argues in their reply brief, which again is just totally inconsistent with what's in the record. They say that it's apparent that the court found that they made a prima facie case, but then went on to decide that questions of fact were present. But that is not accurate. The trial court's opinion says that Rochester Regional Health failed to make such prima facie showing as to the informed consent claim. That is at the top of page 9 of the record. So the reason why, and it's obvious why the court found that, because the hospital is bringing up this fact that our expert affidavit didn't prove that there was no informed consent, but their affidavit also says nothing that's not conclusory or anything about the standard of care for informed
So
consent.
if they don't meet their burden, then you have no obligation to present anything.
Exactly, yes.
Okay, and I promise that's something that, we do as a regular basis at the appellate court, is examine the burdens. In fact, it's something we'd like everybody to do a little more of that, but yeah, we will look very carefully at that. That's really up our wheelhouse.
Okay, that's great. And it's important to know that what the hospital does say, what does claim about what they prove and what they're asserting is meeting their burden is these 2 paragraphs on page 1736 of the record, part of Dr. Bertoya's self-serving affidavit. You'll note that those paragraphs don't use the word standard of care. They don't talk about what the standard of care requires. They don't say that it was met here. It only talks about the facts that support the hospital's position rather than viewing the facts in the light most favorable to the non-moving party. I think that's all I wanted to cover. So just, the hospitals and Nurse Haskin failed to support their burden of the motions for summary judgment, and this court should uphold the ruling below.
Thank you, counsel.
Thank you.
Okay, case number 111 is submitted. Case number 112, Matina Property Management Inc. versus Gabrielle Matina Alfieri.
That's not right.
No?
It's 113. That's
Oh,
113.
excuse me. I have some out of order on my part. Let's start with what 112 really is, which is Victoria Winky versus et al. Okay. Both counselors here.
Good morning. May it please the court. Peter D'Annunzio from Clyde & Co. US LLP on behalf of the appellant, Hedman Resources Limited. This case presents 3 jurisdictional questions of substantial constitutional import, the decision of which will broadly affect litigants across New York State. The first question is, are New York courts going to enforce CPLR 311B as written and as the legislature intended when establishing the jurisdiction of Supreme Court? The second question is, will the burden of proof as interpreted and applied by the Court of Appeals continue to be applied when New York plaintiffs attempt to invoke Supreme Court's jurisdiction over foreign litigants? And third, will a grant of expedient service in one mass tort case be permitted not just once, but for all future cases without any further jurisdictional inquiry? And it is respectfully submitted that this court should reverse and vacate the nearly $6 million default judgment imposed in this case, because it was entered without personal jurisdiction ever being validly acquired over the appellant, a foreign corporation, and absent reversal, it will set a far-reaching and divergent precedent. So, the court might ask, why is this motion being brought in 2024 when the default judgment was entered in 2016? And the reason for that is not, as respondent has submitted, because of some purposeful or intentional delay. The reason for that is because Supreme Court entered a stay in 3 closely related asbestos cases where defaults were taken against Hedman, which preceded this one. And that stay order is contained at page 608 of the record. And the reason for that stay is because after those 3 earlier defaults were taken against Hedman, plaintiff's counsel, the same plaintiff's counsel for respondent in this case, initiated insurance coverage actions to collect those judgments in federal court for the Western District of New York. And the court stay order says that further proceedings against Hedman's insurance, which is essentially its only asset, are those proceedings are stayed pending the outcome of that federal court case. Now, that federal court case remains pending to this day. In subsequent to that stay being entered, Supreme Court made clear that further default proceedings against Hedman should be, quote, held in abeyance pending the determination of the federal court cases. And again, that is pages 1253 of the record and 1319 of the record. And these are actually affidavits from plaintiff's counsel and other cases where the plaintiffs have sought to take default against Hedman. Now,
are you just trying to make us feel better about the time frame, or telling us that in fact these claims are too early? Because the federal court claims are, against the insurance company is still pending.
well, they should await the outcome of that litigation. But in 2020, plaintiff's counsel on behalf of other clients became impatient, started to pursue default proceedings.
Counsel, I mean, I'm looking, these are almost all estates. These time is marching on, and maybe even some of the people that are representing these estates are getting older. Is there anything improper about what they did, is what I'm asking, by going ahead and, trying to commence these lawsuits?
Not to commence the lawsuits themselves. I would say that to attempt to prosecute further defaults against Hedman when the court had made clear that it was holding further default proceedings in abeyance, I would say it's not consistent with the spirit of the stay or the court's directive.
Okay, but we're still talking about a substituted service. We're talking about the commencement of actions, aren't we?
We are.
Okay.
And so the fundamental problem in this case, perhaps the biggest problem, is the plaintiff have used attempts to effect service in 2013 in a different case to eliminate having to meet their burden to establish jurisdiction in all future cases. And this record demonstrates, I think, powerfully why that not only is that a problem, but it's not consistent with traditional notions of fair play and substantial justice. It's not consistent with how due process works. We all know you are supposed to look at the facts of the case at hand to determine whether an exercise of jurisdiction is proper. And when you look at the facts of this case, it demonstrates that the court was without the authority to order substituted service because service was at all times practicable, meaning capable of being performed against Hedman. And I think the timeline and the time frame here is important. The summons and complaint was originally filed in August of 2014. In October of 2014, while plaintiff says they shouldn't have to attempt service at Hedman's registered address with the Ontario Ministry of Government Affairs for receiving process, because they claim now, although they never made any attempt at the time, that no one is at that office. Well, in October of 2014, 2 months after they filed this action, plaintiff's counsel filed a judgment which sought to be enforced at 202 Bentworth Avenue, Hedman's registered address for receiving process on file with the Ministry of Ontario, that they say they shouldn't have attempted to serve through. More importantly, this case has a fundamental difference from a case called Richards, where this court rendered a decision with respect to service. That case really only dealt with service under BCL 307 through mailing to a registered office, because the time frame in that case primarily dealt with post 2016, which was after Hedman was dissolved. So because Hedman was dissolved, the question of service upon Hedman's present was not raised, briefed, or argued in the Richards case. In this case, predated Hedman's dissolution. So service on Hedman's president was a method of acquiring jurisdiction over Hedman. And the record clearly demonstrates that not only could he have been served, but he actually entered into an agreement with plaintiffs to accept personal service in all future Hedman cases.
But that was after the motion was made in this case.
So
the agreement's December 2015, the motion's made May of 2015. So 6 months later, he says, I'll accept service, but the judge didn't know that at the time she decided the motion in May of 2015. She didn't know that he was going to do that 6 months later.
Well, so respectfully, Your Honor, the judge did and should have known that, because the affidavits of service from the process server say that Mr. Adele would accept service. They reflect that the process server called Mr. Adele about serving him personally. And the process server's affidavit says that Mr. Adele is not available to be served with process until later this week at best. And the process server, in response to that, did nothing further. So
You mean they didn't change their tactics to meet Mr. Adele's unavailability or his whim of let's do this at a coffee shop or whatever? I guess I'm trying to figure out if counsel for the plaintiff needs to do that and needs to, adjust its efforts to begin a case because of the unavailability. We don't know why he was unavailable. I guess I'm not understanding the chicken or the egg. They attended to service him and then he says, well, maybe I'll be available this week sometime. Check back with me. I don't know that it works that way.
So it works the way that it is incumbent upon them because they have the burden. The Court of Appeals in a case called Flick said the incontestable starting proposition in cases of these kind is that once jurisdiction is questioned, it is the burden of the plaintiff to demonstrate that they have satisfied statutory service and jurisdictional prerequisites. So it was absolutely incumbent upon plaintiff to have their process server go back. And they never did that. And the other problem with the orders in these cases is they actually never performed any analysis. If you look at both of the orders, the Richards orders from November of 2013 and the order later entered in this case in April of 2015, they contain no reason. They contain no other than to say that the relief was granted because, quote, there was no opposition thereto. So the court never performed the inquiry in these cases. What the court did was assume, based on what happened in 2012 or 2013, which was a much more disruptive period after Hedman's primary carrier exhausted, that no one would ever accept service on behalf of Hedman. Now, the court also never looked at whether Hedman could be served through the Secretary of State, which plaintiffs admit they easily could have done. So one of the fundamental problems with these orders is they don't perform the jurisdictional inquiry, which gets back to my initial point that it's really just based on an inquiry that was done in a prior case. And, we don't just have the affidavit from the process server in December 2014. We have Mr. Adele's affidavit in early 2015, which predates the April 2015 substituted service order, where he's saying, as far as I am aware, no one at Lipsitz has ever called me or emailed me to verify Hedman's mailing address, which he's correct about, because Hedman's mailing address has always been Bentworth Avenue. It has remained Bentworth Avenue throughout the entire relevant time period in this case. He goes on to say,
he have returned mail from that address in the record. Why is that insufficient for the court to consider that the mail was returned from that address?
Well, the court should consider it to show that service was practicable on Hedman. And so that's also important. I think a fundamental problem with the Richards decision is it says that the facts in the record show that because Mr. Adele said Hedman did not have an office after 2007, that meant that Hedman does not have an office, a post office address for on file with the Department of State or equivalent authority in the jurisdiction in question for the receipt of legal process.
So the mail wasn't returned?
The mail was returned with a signed green card. So it was delivered, and then it had a signed green card showing that the delivery was accomplished. So my point is that the plaintiffs in related cases are effectively serving Hedman by mailing process to the Bentworth Avenue address. They're getting signed green cards back. They're filing affidavits of compliance, and they're serving consistent with BCL 307. There's nothing to stop the plaintiffs in this case from doing that. They never tried. They never explained that they had tried. There's no evidence in the record that they have tried. So they could have served Mr. Adele. They could have served by mailing to the Bentworth Avenue address. And to be clear, we do not know who is signing those green cards. We don't know what affiliation with Hedman, if any, that they have. They speculate that it's not someone affiliated with Hedman, but they don't know that. And again, it's their burden of proof, particularly when the consequence is a $6 million default judgment. And that raises another important distinction with the Richards case. The relief grant.
Just on that last point, before you move on. So the plaintiff, sure, they get the green card back, but they also see that the mail's returned back. So they know that no one at Hedman is getting the letters. So the plaintiff's fault was that the plaintiff was concerned that Hedman really wasn't getting the letter. They should have not been concerned with that. They should have said, green card, we're good. I don't care whether they get it or not. That's what you're claiming the plaintiff should have done here. And that's where they erred. Right?
They did err in doing that because the Court of Appeals has said in Flick and a line of decisions consistently interpreting the Flick case that adherence to the process set forth in BCL 307 is a mandatory sequence of service progression options that are required in order to establish jurisdiction over a defendant. They do not have the right to choose not to do it.
But they did it. They made the mailing. It came back.
So they didn't do it in this case. They did it in other cases. So that's the distinction. We put that proof in to show that they could have done it, but they didn't. They never made the mailing in this case.
Okay, they mailed to other addresses.
They
Bloor
did.
Street address, right? Is that what I'm?
True. They mailed in other ways that were not consistent with the statutory requirements.
Why was the Bloor Street address the wrong place to mail something?
Because it was not Hedman's registered address for receiving process on file with the Ontario Ministry of Government Services, which is what BCL 307 required him to do.
That was their second attempt. The first attempt was at 100 King Street.
True. So if I could go back to a critical distinction between this case and the Richards case, it's the relief involved. In Richards, the trial court entered a default on liability only. They permitted Hedman to appear and defend against damages and to seek an offset for prior settlements. That's important because this is an asbestos mass tort case where plaintiff ordinarily sues dozens of defendants and resolves with dozens of defendants. So each defendant's liability in a case like this is a comparatively small fraction of any verdict or judgment. And in Richards, Judge Shines was sensitive to that. So yes, she entered the default on liability. Yes, that was affirmed. But at the end of the day, there was not a prospect for a double recovery because Hedman had the opportunity to appear and defend against damages. Here, there's no such opportunity. Here, an affirmance will produce a massive windfall to the plaintiff because the plaintiff, in fact, named dozens of other defendants in this case. As is typical in asbestos cases, it's fair to suppose that the plaintiff has resolved with dozens of those other defendants, and now we'll add a full recovery on top of that. So in addition to the public policy reasons against applying a substituted service order in one case broadly across dozens of other asbestos cases, you have another fundamental public policy problem, which upholding this default will produce a massive windfall to the plaintiff. So we believe Richards is distinguishable because this does not involve the question of can service be affected on Mr. Adele. We think there's a consistent time frame from the process service affidavit in December 2014, saying if you come back next week, I'll accept personal service.
Maybe.
Well, we also have his own affidavit earlier in around February 2015, where he says, no one from Lipsitz has ever contacted me to see whether I would accept service of process or verify the mailing address. And, you know, before that statement is discredited, I think it's fair to submit that the trial court cannot both credit Adele's statement in that affidavit that Hedman doesn't have an office and discredit his statement that he wasn't evading service of process in the same affidavit. I don't think that that's a fair, rational way to construe that affidavit. But then beyond that, we have from July to 2015, plaintiff's counsel negotiating a service agreement with Mr. Adele. And yes, it was after the April order, but it was over 6 months before the default judgment entered in this case. And when you consider all the other steps that weren't taken, and you have an ex parte substituted service order that was issued based on the fact that it was unopposed, that does not comport with traditional norms of due process. And we submit that it's unconstitutional. So, and then just to clarify one point, the proof we put in about the plaintiff's effort to mail process to Hedman's registered address with the Ontario government, that was done in later cases. It was not done in this case. So unless there are other questions?
I think we have to do plenty.
Thank you.
Thank you. All right, counsel?
Good morning, Your Honors. Dennis Harlow of Lipsitz, Ontario, and Comerford on behalf of plaintiff respondent Nancy Muir. Your Honors, in April 2015, when Justice Trines decided the substituted service motion, she had before her affidavits from 6 different process servers recounting 9 separate attempts at personal service on Mr. Adele during December 2014. She also had before her the January and February 2015 affidavits of Mr. Adele. In those affidavits, he describes himself as a titular figurehead of a defunct business. He avows that he has never accepted service on behalf of Hedman. He vows that his office staff has been instructed not to accept correspondence directed towards Hedman, even when it's directed to Hedman through Mr. Adele. Indeed, he vows that on the occasions that they have done so, they've done so erroneously and in violation of his instructions. He further avows that Hedman went out of business in 2007, and that the office that it previously rented is no longer associated with the corporation in any way, shape, or
Where's
form.
that?
What's that?
What address is that? Is that the King Street or the Bloor Street?
Route 2 King.
Yes, it's King.
Bentworth Avenue, isn't it?
Yes, it's 202 Bentworth Avenue. It's currently occupied by a religious organization, Your Honor. The trial court judge is entitled under these circumstances to look at the full facts and evidence before her and conclude that Mr. Adele is not amenable to personal service and that it is not reasonable to send process under 307 to some unrelated third party that we know will not be able to communicate that to Hedman. And it's worth looking at exactly what steps we would follow if we proceeded under the course of action that defendant insists that we must. What we do in those cases is we serve the Secretary of State, who we know does not have a forwarding address for Hedman because no such address exists. So presumably that gets filed away in perpetuity. We then mail process to the Black Hebrew Israelite Temple of Greater Toronto that currently occupies the building. And they send back a green card and write on it, Hedman not here, and so forth. We know to a certainty, both from the affidavit and from the returned mail, that this is not a method that gets actual notice to Hedman. The CPLR 311 statute allows the trial court to apply its discretion and determine whether a state of impracticability of service exists.
The defendant makes reference to Flick versus Stuart Warner, which is a Court of Appeals case where a plaintiff attempted to serve an unregistered foreign corporation through Business Corporation Law 306 instead of 307. And the Court of Appeals held that these statutes are not fungible and that the violation or the corporation's rights were violated by the use of the wrong steps. But I think it's worth looking at the court's specific reasoning. It states that the technical requirements of 307, quote, are designed to satisfy the due process requirements of actual notice. There was no way that 307 service would supply actual notice in this case. The defendant has speculated for the first time in oral argument that perhaps there's some phantom employee of Hedman's who was really at the address and was sending back the mail, but there's nothing to suggest this is the case and much to suggest that there's not. This court in Richards found that Justice Chimes could, under identical circumstances, determine that, yes, those methods are impracticable. And this court was following a long line of pre-existing precedents when that occurred. In the Civ Steele case from the First Department in 1999, the court declined to require the use of nonsensical 307 service under similar circumstances. In the Germain versus A.O. Smith case from the First Department in 2014, the court approved substituted service on the defendant's excess carriers rather than mailing it to a building that had been long vacated. These are common sense steps that fulfill the requirements of due process. And indeed, the substituted service order that Justice Chimes entered was entirely conventional. It satisfies the constitutional due process requirements by requiring that an adult of suitable age and discretion at Mr. Adele's admitted place of business receive the process. The defendant goes on to argue that this case may differ from Richards, which they frankly admit they believe ought to be overturned. But they say that in this case, if we just pursued Mr. Edel more ardently, then perhaps he would have eventually accepted. And the fact that, a year later he came to a different arrangement is used to suggest, well, you just needed to push harder in December 2014. The single process server affidavit that they cite is taken out of context and actually directly misquoted in their brief. As Justice Bannister observed, he didn't agree to accept process. He said, no, I won't accept process today. Leave it with my staff. He implied that at some point in the future, he might be willing to accept process, but that's belied by his longstanding pattern of evasion. By the way, the defendant referred to the substituted service motion as being ex parte. Although the statute does permit us to bring that motion ex parte, if you'll look at the record, in this instance, we actually brought it on notice to Mr. Adele, and we sent it to all of his available addresses and also to his email address, which he had provided in the previous motion to vacate. There was certainly no attempt to hide the ball here, and Hedman had every opportunity to appear and address the matter. Defendant also implies that there was not a deliberate default in this case. That is completely belied by the record. If you look at page 1185 of the record, there's May 6th, 2015 correspondence from attorneys for Hedman's excess carriers, where they indicate in no uncertain terms they have no intention of appearing and defending or settling the pending Muir action specifically or any other. They indicate that they're going to rely on their coverage defenses, which they have every right to do, and which they are presently asserting in federal district court. However, this is important because a defendant who engages in deliberate or strategic default is specifically not permitted to argue that they've been prejudiced by the case moving on without them.
And it does show their awareness of this litigation.
Oh, yes, their awareness of and annoyance at this litigation. There's additional correspondence in the next couple of pages of the record from 2016, where they reiterate that they have ironclad coverage defenses and we should stop corresponding with them. There's no suggestion that they were defaulted in the passive voice or that any of this was done without their knowledge. The defendant invoked several general statements about New York's preference for adjudicating matters on the merits. However, crucially, all of these cases expressly on their terms do not apply to strategic or deliberate default. The defendant also makes reference to various cases where trial court judges have improperly entered defaults in the absence of evidence of negligence. But this is certainly not the case here. Justice Chimes heard a 2-day bench trial. She heard from 5 witnesses. She heard specific evidence of negligence. She admitted and reviewed 72 exhibits, and then she issued a detailed decision with numerous findings of fact. So this is not a procedural shortcut or getting one past the goalie. This was a fully adjudicated action. The defendant has made some reference to Justice Lane's 2013 November order in the Richards case, which was an earlier order that he granted right after Hedman's previous counsel had withdrawn. Hedman's previous counsel had indicated that Adele could be served at his then current office address, and that's how one could reach Hedman. Justice Lane entered an order memorializing that. However, that order was not used in this case. It was referenced as part of the history of evasion.
Sure, and we don't have to follow Judge Laney. We have an order of this court.
Precisely so.
Confirming that. So I think we understand.
Okay, thank you, Your Honors. Are there any further questions?
I think we're good. Thank you.
Thank you very much.
Case number 113, Matina versus Matina Alieri. Okay, Mr. Miller is going to appear virtually. Here he comes. Okay, counsel, you may begin.
Thank you, Your Honors. Good morning, Your Honors. May it please the court, John Manier from Ralph Larigo's office. I'm here on behalf of the appellant today. Essentially, this is an appeal from the lower court order dismissing the complaint pursuant to or under CPLR 3211. Under 3211, and this court's precedent set, the Court of Appeals precedent set in Sokoloff in 2001, the court must accept as true the facts as alleged in the complaint and submissions in opposition to the motion and accord plaintiffs the benefit of every possible favorable inference and determine only whether the facts as alleged fit into any cognizable legal theory. We asserted 3 causes of action, 1 quiet title, 2 declaratory judgment, and 3 tortious interference.
Now, counsel, let me ask you this. Are we supposed to ignore, the prior cases of this court that were pretty recent, involving these parties?
Your Honor, respectfully, the procedural posture of this case is such that it is a motion to dismiss. This court must accept the facts alleged as true, set forth in this court's precedent, the Court of Appeals precedent. That's the law. That's the rule. Despite what happened in other cases, that may impact the outcome of this case at a future proceeding. But before the lower court and this court is simply a motion to dismiss, accepting all of the facts as true. And we have the facts, we've alleged the facts, not only in the complaint, but in papers in opposition to the underlying motion. And those facts are as follows. The appellant purchased the property at issue for fair market value. There was no opposition or anything raised that purchase price.
And I'm just going to tell you, we read all of this and we understand everything you say now and are about to say with regard to the timeline. I guess my biggest hurdle to get over in this case is the fact that we've had other cases, not just other cases, we've had cases with these parties over this very property, which said she's not the owner. Do we have to ignore that? I guess is my question to you.
And I can answer that question.
And I think your answer is yes, we need to ignore that for the procedure. We have to go.
Not necessarily, Judge. And here's why. Because the appellant was not a party to the underlying litigation. It never was. In fact, the appellant tried to become a party to that underlying litigation. We brought a motion to intervene. It was expressly denied. Despite the fact that we had title to that property, it was properly filed. We paid fair value for that property. That said, Your Honor did indicate we've had dealings with these same parties. They are not the same. This is a separate and distinct entity.
How can you say you paid fair value for the property? There was never an opportunity for anyone else to to make a bid on this particular piece of property. The listing agreement was made one day. 2 days later, the deed was filed, and
Your Honor,
where's the posting? Where's MLS? Where's someone coming in? I mean, the listing agreement said the realtor had that obligation to do that, to do all that, and it was never done. So it didn't give the opportunity to say, "Hey, I'm familiar with that property. I'd like to bid on that." And this price was set in the listing agreement. That was it. Someone else could have bid that. I mean, it seems as though, I don't know, when I look around, there's aggressive bidding on properties. Once they become available, the bidding process is rather significant, and the ultimate price is well over the original listing price. So that, in those instances, I'd argue that would be a fair market value purchase.
Your Honor, I agree with you, but those are not points that could be made in the underlying court because of the fact that all of the facts as alleged in the complaint must be accepted as true.
So you're coming here saying it was a fair price.
We are, Judge.
I'm saying it's maybe not.
But how do you get to that, respectfully, Your Honor, how do you get to the inquiry of a fair price when we're simply accepting the facts as alleged as true? So we don't even get there. And it very well may get there, but not at this stage. And if we give credence and respect to case law and precedent and statutes, which are, this is black letter law, this is abundantly clear. At this procedural posture, the lower court erred. And again, even going forward and moving beyond the 3211 standard, the basis for the court's order was collateral estoppel. I mean, that was the basis. And this court said in 2024, and I cited the case in my papers, Wiltberger as trustee of Walter N. Welsh, 2006 Revocable Trust versus Allen. Collateral estoppel bars litigation of an issue when the identical issue necessarily was decided in the prior action and is decisive of the present action, and the party to be precluded from relitigating that issue had a full and fair opportunity to litigate that issue. We do not have that here. Clearly, the facts and the arguments set forth in the record in the briefs, we don't have those facts. We tried to intervene in that lawsuit. We tried to assert those arguments, litigate that issue. It was expressly denied. We never were a part of any order. And when I say we, I mean the appellant. And to base the decision on collateral estoppel is contrary to this court's precedent set in 2024. It's contrary to what collateral estoppel is as a legal theory and how it could be asserted in this instance.
I mean, the court mentioned collateral estoppel, but mentioned res judicata, said whatever you want to call it. It's a little bit unclear as to the basis of the ruling. We have the July 18th, 2023 order, and we have an argument that constitutes documentary evidence sufficient under 3211. And you've seen motions like that before. Is your claim that it's not sufficient? The order itself isn't sufficient because you moved to intervene in that proceeding and were denied, so that's why you can't rely on the order, that you didn't have an opportunity to contest it? Is that the reason why it's not sufficient?
Both, Your Honor. Respectfully, I believe that Judge Walter in his decision, the commentary from the court while he was rendering his decision indicated, Mr. Munir, I would accept your position based on the July order, but not on the June 22nd order. And I believe that the underlying court's collateral estoppel decision is based on an order from June 22nd. And yes, going forward with the second part of your question, Your Honor, the lower court indicated that the June 22nd order barred the appellant from raising these claims. But that just cannot be true, because what collateral estoppel is, same parties to an action, identical.
No, we know that.
And because of that, the lower court erred. And this very well may come out down the line on a dismissal or a summary judgment, but certainly not at this stage or this procedural posture. I'd ask the court to reverse the lower court decision in its entirety and send it back for further proceedings.
Thank you.
Thank you.
Hey, Mr. Miller.
Good morning, Your Honors, or afternoon. Andrew Miller on behalf of defendants, the estate of J.J. Alieri. I think this is perhaps the easiest appeal the court has addressed today. And at this point, this litigation is really just an end around by co-defendant Gabrielle Matina to take her third, fourth, or fifth stab at trying to get title to this property. This is an extraordinarily simple issue. In order for a real estate transaction to be valid, the seller must have the authority and ability to sell the property. At this point, there are 6 judgments, orders, or decisions holding the co-defendant Gabrielle Matina does not have the ability to sell the property. The first,
I guess counsel's argument
Sure.
is pretty simple. They believe that the court sort of jumped the gun, should have denied the motion under 3211 and maybe did some discovery, and then all of these issues could come before us. What about that argument?
well, Judge Walter was he knew what his own decisions had said, Your Honor, and his own decisions had previously said that Gabrielle Matina did not have the authority to sell the property. So it would be, frankly, contradictory and inconceivable to think that we're now going to have an issue of fact relating to a decision that's already been ruled upon by the same judge. And respectfully, this court has issued a similar ruling in October, upholding the dismissal and the award of sanctions against Ms. Matina. And so this issue has been fully decided. And for a purchaser to be able to come in and challenge a real estate transaction where the seller never had the ability to sell a piece of property, and there are multiple court orders holding that,
Counsel, what about the position that the appellant, Matina Property Management, Inc., is in fact not the same party that's been involved in the other litigations? It's a stranger to those litigations, and we shouldn't prejudge that.
Well, it can't overcome the fact that the seller, there's a ruling here that the seller didn't have authority to sell the property. And no matter what Matina Properties does in the litigation, it's never going to be able to reverse Judge Walter's order that says Ms. Matina didn't have the authority to sell the property. That issue has been decided multiple times.
And again, we don't do what Judge Walter's order says. We have an order of this court saying the same.
Correct.
Okay. All right.
So I think the court understands my position, and I'll answer any other questions. Otherwise, I'll rest on my papers.
Thank you, Mr. Miller.
Thank you, Judge.
Okay. Case number 114 and 115, McDonald versus State of New York.
Hello again. Attorney Michael Whitmer. I'm here for appellant Sherry McDonald. This case is a Court of Claims 8B wrongful conviction action where we're seeking reversal of the dismissal in this case. In particular, in relation to Ms. McDonald's case, or any 8B case, the two things that you're looking at are the two prongs, which is one of them being innocence and the other one being the contribution. In this particular case, the court found against claimant for both, but for the reasons that I'll state right now, we're asking for a reversal. In relation to the contribution factor, which is whether or not the claimant contributed to their conviction, in this particular case, the court's decision ultimately came to the conclusion that Ms. McDonald's statements were a proximate cause of the conviction. One of our biggest positions on this is that if you look at the case law, particularly in relation to the Warney case, among others, that the real standard in an 8B claim for contribution is whether or not it is the proximate cause.
And we understand the difference between those two very clearly. So you can continue.
Understood. So I'll just say very briefly, there's cases that talk about inconsistent statements, Fortunato, as opposed to Moses, which comes to the opposite conclusion. The main point of it is that it's inconsistent statements they can be considered for purposes of the contribution prong. But for this reason, I think that there was also a problem is that when the court considered whether or not the claimant's statements actually contributed to the conviction, first off, I think that the court was unwilling to really go into the coercion analysis after having decided that they wanted the live testimony to be able to hear the coercion argument. But in this particular case, the court made a distinction about the claimant's statements that they were not confessions, that they were exculpatory. I don't think that there's any basis in the law, in the case law, that because any inconsistent statements, just like in Fortunato or Gristwood or any of those other cases, that inconsistent statements that are not confession should not be considered.
Doesn't that presume that there is some other proximate cause, that the language, it wasn't just a typographical error, the approximate cause to approximate cause, that there are others out there. I looked for one in your brief to see, like, are you asserting another cause? On page 15, you'd written that the conviction resulted from the prosecution's theory of accomplice liability, that was the other. And I guess it seems to me that that's conclusory. So could you explain that to me? What do you mean by that?
So if I look at this case from what could be the proximate cause of the conviction, I would say that the proximate cause is just like the procedural history of this case, where Ms. McDonald was convicted at trial. She went up on appeal. It was reversed by this court, and it was reversed on legal insufficiency and secondarily against the weight of the evidence. I think what was the proximate cause was Gigi Pena's testimony that claimant was in the bar and that she was the lookout that eventually set up this murder. And the most important part for the innocence component of this case is that, just like this court found in 2019, when the argument was made, the reason why there's legally insufficient evidence, and in addition, this court came to the secondary conclusion that it was against the weight, which is normally not, you kind of would do it the other way around, is because the entire theory of the prosecution was that she was in that bar, she set this up, she was the lookout. And then when they go back and look at all of the surveillance tape, there's no evidence that she was ever there, and it proves that she wasn't. And in addition to that, and in this trial, the bar owner also came in and testified and was like that she wasn't here.
Right. So how could that be a proximate cause of the conviction when it was so clearly contradicted by the video testimony? It couldn't have been that.
So my theory on this would be that just like how the court had to step in 2019 and be the 13th juror and say, well, this clearly was legally insufficient and it was clearly against the weight of the evidence because of these things. Similarly, there's no evidence to be able to say that there was any justice to the jury's verdict in the first place. You know, the jury's verdict didn't make any sense to begin with. So paradoxically, it's like, how could this be the proximate cause when those statements didn't have anything to do with why she was convicted? And she clearly was not rightfully convicted if there was legally insufficient evidence from the first place and the court got it wrong in the first instance. I mean, the TOD got denied, then it got denied again. It should have been granted, obviously, based upon this court's determination and based on that. But I think it's also, you know,
we don't get there if we don't first overcome the innocence prong. Mentioned the judge found both. But let's talk about this. How did your client prove that she was innocent of this?
Well, the prosecution's entire theory to how she was involved in this murder at all was that she was at that bar. Gigi Pena sees her. She acts as lookout. She tells her boyfriend. The boyfriend comes out in the car, drives around, and eventually kills Brady Davis. If you look at the video, it's very clearly that there's a man that's involved in this. And then if there is even a second conspirator or co-defendant that was uncharged, that person was also very clearly a man from the video. And we have a claimant, a female claimant in this particular case. If you prove that she wasn't there, which also there's also corroborating evidence from the cell phone evidence, from her own testimony, from the bar owner's testimony, and that proves by clear and convincing evidence. I think that proves that she's innocent.
Because she's not physically in the bar a half hour before the shooting?
Because she had nothing to do with this shooting at all.
See, that's different. Having nothing to do with the shooting and not being in the bar are two very separate things. Doesn't she have to prove she had nothing to do with the shooting? And here we have a lot of evidence that she supplied the vehicle, that she may have been contacted right before as to pick up, and so, I mean, none of that, it seems, was disproven now at this trial.
I would say similarly, I don't think it was disproven by the Attorney General's office when that evidence was put on, when she testified she wasn't there. She testified she had nothing to do with it. Cell phone evidence corroborated it. All the surveillance video corroborated her theory as opposed to the prosecution's theory, which obviously could not have occurred.
How did the cell phone evidence corroborate it? They were so close. The house where she was and the bar were so close, they could use the same cell tower.
That's true, but I think the prosecution's theory also is that she'd go somewhere else later on in the night, and the cell phone evidence didn't corroborate that. In relation to the coercion part of this too, I just from Ms. McDonald's perspective, she really didn't even get an opportunity to put on the case that she wanted to put on, based upon the fact that obviously she had noticed an expert to testify in relation to the coercion aspect of it. One of the unfortunate things, I guess, for Ms. McDonald, despite the fact that she had her murder conviction overturned, is that she never got to a Huntley determination either on this case. And if she had gotten to the Huntley determination, that might have made the court had to say that, yes, these were by definition involuntary, but she never got to actually have that determination by this court, because this court didn't need to reach that based upon the fact that they were already reversing on against the weight of the evidence and legal insufficiency. I think that the trial court and the Court of Claims, their determination that there was no reason to have the claimant's expert testify on the involuntariness of her statements, and then simultaneously allow that to be the basis for that contributing to the conviction, when all the case law kind of seems to suggest that that's the opposite conclusion we're supposed to be drawing. Warney is that's the case that's talking about that. Bristwood's talking about that. And the claimant should have had that opportunity to be able to put on their case without this distinction of confession versus exculpatory inconsistent statement being the basis for the decision. It's our position that that claimant very clearly met her burden of clear and convincing evidence for innocence. And it's also our position that they did not show that these statements contributed to her conviction. But
the problem with the expert's testimony, I mean, normally you'd expect the expert to testify that the police coerced a witness or a suspect into saying something that wasn't actually true. Right here, we don't have that claim. So what was it? Would the expert actually opine about that? That she was nervous and that, and what did she admit? There was nothing to admit.
I think that she would be able to state that she was coerced into making.
Saying she had nothing to do with it?
No, but she lied about other things. There were lies in the interrogation. And I think that was the distinction that the Court of Claims judge made, was that, yeah, there were lies, but unlike a lie that's a confession, there's no right.
You assume that you lie to help your own self-interest.
Yes, but at the same time too, if those statements are involuntary from the very beginning, I mean, that should be a consideration. Just based on the law itself, I think that the cases talk about inconsistent statements are not necessarily a basis for the proximate cause for the contribution. That's the Fortunato case. And Moses comes to the opposite conclusion, but that was a false alibi, and there was no other corroboration. So it had to be. That is the case that says like there was no other reason this could have been. And that's what's so important about the theory of the A proximate cause versus the proximate cause, is that the statute and the legislature doesn't want us to just, throw away all these cases, if there's no, they're not DNA cases or something like that. If there's another basis to be able to say that could have been a proximate cause for the conviction, then we're supposed to hear that out. That's it. Any more questions?
I think we're good, counsel.
Thank you very much.
Good afternoon, Rachel Raimondi for respondent. Justice Bannister, just a couple of cases ago, you stressed to the bar the importance of analyzing the burden of proof here. And it's appellant's burden of proof to demonstrate by clear and convincing evidence, so by a reasonable certainty that her version of events is true, that she did not cause or bring about her conviction, and that she is actually innocent of this murder by accomplice liability. And here the theory was not that she was in the bar at some point that night. That's not material to whether she was the getaway driver, which was the people's theory of this case. It's not enough to demonstrate that the people didn't prove that theory beyond a reasonable doubt. And I'll start with the innocence. There are two different grounds on which this court could affirm. The first is on McDonald's failure to prove that she's actually innocent. She tried to do this largely through her own testimony, which the Court of Claims reasonably found in this case was not so compellingly credible as to constitute clear and convincing proof. Here, her statement that she isn't involved is self-serving, and she had already admittedly lied about her participation in this very murder.
Oh, as I recall, the case from this court that overturned her conviction was very narrow, and it talked about the element of intent, that they didn't prove a joint intent, that her intent and the actual killer's intent were the same. And that's very hard to prove. Okay, so on that basis, that was what needed to be proven, and it wasn't. Okay, regardless, they had convicted her based on a whole bunch of circumstantial evidence. So you have that ball of evidence, before us. Her showing up after the event, the phone calls, then the lies. I mean, there are a bunch of things that in this case that make it hard to accept the fact that she's innocent of this crime. Don't you believe?
Well, no, this is for a money judgment. It is her burden of proof that she's actually innocent. This statute is for people who can prove somebody else has already confessed to doing it, or I have plane tickets and I was in California. What she's pointing to is that the people's case was weak, and admittedly it was. But
I believe that's exactly what Judge Bannister is trying to say. Everything else that you had in the trial pointed to that perhaps she was not innocent. Her innocence was not proven. Just because she's found not guilty, or just because it's reversed, doesn't mean she's innocent.
That's exactly correct. I'm sorry, I misunderstood what you were saying. Yes, that's exactly right. Additionally, the weaknesses in the prosecution's case and all of that circumstantial evidence, it was McDonald's burden to prove below that she didn't contribute to her conviction through the development of the consciousness of guilt evidence. And here the prosecution had 5 actions that it told the jury it should infer her guilt from. And that was lying about her whereabouts, Phillips's whereabouts, whether she had a cell phone, whether she lived in an apartment where a black ski mask was recovered. And in the hours after the murder, she stopped driving her car and she attempted to sell it. the prosecution harped on that as the reason here, and Ms. McDonald just hasn't proven that did not contribute as a substantial factor for the jury in how they viewed the case. Counsel made a lot about the idea that she was coerced, but she didn't have, she was not denied an opportunity to put on evidence that she was coerced.
She was coerced. How does it change all of those other items of evidence that we just talked about?
Well, right, no, it doesn't. Here, factually, she's saying that she lied here to protect Phillips. So factually, I would dispute the idea that she is coerced. And if the court has no other questions, I'll rely on my brief.
Thank you very much.
Thank you.
Okay, cases number 116, 117, 118. Willsman versus Benson. I get to say good afternoon to you because it is past 10.
Good afternoon, Your Honor. Michael Higgins from Ernst & Dressy for Acadia Site Contracting. This case concerns the scope of an indemnity agreement between a property owner and a snowplow contractor. The indemnity agreement was specifically limited by the scope of the services in the contract.
It looks like there's two parts to the agreement. You in your brief on page 7, you italicized the two parts separately, and then you also mention on page 25 that there's two separate parts. The first part is that the plaintiff's personal injury claim arises out of or results from Acadia's performance, but it seems like, and that seems to be the focus of everything else, is that first phrase. There's the second phrase, provided that such action was caused in whole or in part by acts or omissions of the contractor. And here we have the 0% negligence finding by the jury, which would seem to sort of contradict that second piece. Even though maybe it arises out of, you still have it seems like the causation element, maybe the second piece is a little bit more narrow than the first piece. My question for you is that your argument? Or am I making that up?
Well, I think that in either case, whether it's just the arising out of language or it's the caused by, there still has to be a causal element. And the jury's finding of a 0% is indicative that there is no causation between the acts or omissions of my client and the fall. So whether you read the indemnity agreement to require that causation in the second clause or in the first clause, there has to be some causation element. And the jury's finding, while not specifically a finding about whether it arises out of, should be a strong indication that it was not the cause of the fall.
Counselor, this went to trial, but the issue that's in front of us is summary judgment.
Well, I think both issues are in front of you. The narrowest ground you could determine on is the summary judgment and remand for a determination about whether or not.
Well, could we just start with summary judgment for a moment?
Yes.
So we have a decision which is then followed by an order.
Correct.
And then we've got a motion to re-argue that you've filed or your client filed.
Correct.
But on the initial motion, the decision has language that we might call limiting. And that decision could be read as a denial of the motion for summary judgment, in as much as that decision says there's a question of fact that has to be presented to the jury.
That's right. It says that it's conditional on a finding about whether or not the fall arose out of the acts.
But if there's a question of fact,
yes,
on a motion for summary judgment, that means no summary judgment. That means a denial.
Correct.
But when we look at the order doesn't have that same limiting language.
Correct.
Right.
And my understanding, as you read the record, and as I read the record, there's really no explanation of the difference between the decision and the order, other than the fact that the parties could not agree on the language that went in the order. And the court appears to have perhaps changed their mind or entered an order that's inconsistent with this decision. So the decision said that there is a question of fact, And then we,
So what I'm sorry to jump in here. But
Yeah.
Your position here is that the jury should decide that question. The
Yeah.
jury should have been presented with that question,
yes,
and that wasn't done here.
correct.
Who had the burden to present that?
Who had the burden to present that it arose out of?
That it was Acadia.
Well, Benderson had
They had that burden.
correct. They had that burden. They had that.
They had the burden to present it to the jury. And
Yes.
they had the burden to present it as a question to the jury.
That's right.
All right.
All through the case, both at the time of summary judgment and then later.
Did that issue ever come up? Should we give the jury a specific interrogatory to answer? Because nothing seems in the trial to have been aimed at this question.
Well, that's right, because the summary judgment decision precluded us from having that determination at trial. We had a determination, there was discussion, and there's some of it is in the record about whether or not we can present the contract and discuss the standard of arising out of, and it's not presented at the trial. It's not dealt with at the trial. And so we don't have a jury determination. The closest thing that we have is a jury determination that the fall arose from the acts or omissions of Benderson, not from my client, which means that it's the pothole, not the snow. And if it's the pothole and not the snow, there's no causal nexus. I think, I also submitted to the court a letter that we now have a Court of Appeals decision in Debrino that gives us further guidance about how to interpret contracts of just this variety, where the indemnity clause is limited by the scope of the contract. And it's much more limiting than some of the way in which I briefed the case.
So, Counselor, if we were to conclude that there is a question of fact on that issue,
yes,
and it wasn't presented to the jury, what's the remedy?
Well, the first remedy would be a remand for a jury trial on that narrow issue.
That a trier of fact has to reach that issue.
Yes. Yes, that's the narrowest. The other, we also argue that because of the determination that the proximate cause of this fall was the pothole and not the snow, that you could simply.
Is that fleshed out? What was the question on the verdict sheet?
The question on the verdict sheet. So the question on the verdict sheet, does not really flesh it out. It asks, who is liable, and we get a 0% for my client, and we get 100% for vendors.
Counsel, could you have moved for a directed verdict on this issue?
No, I couldn't have, because I had a summary judgment decision already deciding it. So I couldn't present evidence about it. My client couldn't tailor their defense.
So in that circumstance, this really is a request for us to revisit the summary judgment determination.
Yes, it is. I think at its core, and again, that's the narrowest and easiest decision before the court.
And do you think that the trial record is inadequate for us to review that, or for on motion another court to review that, because you didn't explore the issue specifically because you thought it was resolved?
No, I think you could still make the determination based on the finding that the sole proximate cause is the conduct of Benderson. And because you have to have a causal connection, whether it's arises out of or the second reading of the indemnity clause, either way, you have to have some causal nexus, and we have no causal nexus. And I do want to, ensure that this new Court of Appeals decision is considered, because it really emphasizes, I think, in a couple ways, and expands the court's prior decisions about how we interpret arises out of the contract. It tells us that the reading is that it has to be work actually performed by the indemnitor, and it highlights prior authority that says that in these contexts where it's between an owner and a contractor, not an insurer, that you have to read this indemnity clause narrowly to avoid reading into the contract the imposition of a duty that the parties did not intend. I think that's exactly what happens here, because you have a finding that the fall is because of the pothole. my client has no contractual obligation to deal with potholes. We have no contractual obligation to perform the work in a way that would take snow out of a pothole. We're not required to scoop out a pothole. We're not required to repair potholes, but that's the effect of this. So, I also make an argument that I think you should expand under the particular circumstances of this case, read the anti-indemnity statute to prohibit indemnity under these circumstances, because really what my client would have had to do to avoid liability here is to repair a pothole. And because the reading of this indemnity clause requires us to take that action, it really is a contract now under the particular facts of this to perform construction work, which we wouldn't be able to indemnify a property owner for.
If your opponent argues in a moment that no, you didn't have to repair the pothole, you had to clear the lot sufficiently so that if you're walking with a cart, you see the pothole because it looks different than the rest of the pavement, because it's not all slush around the pothole. It's different. It's blacktop, and then you see it. And, we've seen holes that are filled with slush or filled with water, and you notice it. Oh, gee, I'll move my cart around it, which of course would have prevented it here. How do you respond to that?
Well, I think, one, we don't have a factual finding about that. We don't have good evidence of exactly what that pothole looked like and whether it could be seen. And I think that there's other ways, especially if I'm at trial, that I can try to avoid a finding and get better proof about, what the cause of the fall was, right? And, was she looking where she was going? Did the snow actually occlude it or not? I don't think we really know. And I think it's very clear that the cause was the pothole, and that I would have had to repair the pothole or warn about the pothole's existence to avoid liability. My client would have had to do that.
Thank you.
Thank you.
Good afternoon. May it please the court, Brent Seymour on behalf of the Benderson defendant respondents. I wanted to address some of the pointed questions that were already made to appellant and give a little kind of my response and some context. So Judge Nowak, you asked about there was the arising out of language and then there was the cause in whole or in part by language. But if you read that entire clause, there is an or in between that basically says it can either arise out of or is caused and in whole by part of. So really, if either one of those are met, I think indemnification is owed.
Would it be your burden to prove one or both?
Pardon me?
Would it be your burden to prove one or both?
One or both, and I believe we did based on the
Why is
plaintiff.
the liability or the verdict sheet come back to 100% to you, your client?
Because the verdict sheet was, the question was an Espinal question as to Acadia. I had already proved my cross-claim on summary judgment against Acadia. The plaintiff still had a surviving cause of action under Espinal. So at the time of trial, it was the plaintiff that was pursuing a case against Acadia, the plow contractor, not Benderson. And so obviously we have our three narrow exceptions under Espinal. And the record is very clear here that there was a specific, in the jury charge, it specifically said, and this is in my brief and in the record, that it was essentially, it said, you will find Acadia was negligent if they made the condition worse. It was that exacerbation. So you have to look at what the jury was read, the law and the charge, and then compare it to what was actually on the verdict sheet, which says negligence, right? But that's not really what they're only determining the negligence as to what a plaintiff can bring against a third-party contractor, which is very narrow. And that brings me to another point that Judge Bannister, you brought up, and about what could have Acadia kind of done to avoid this at the time of trial, could they have fought it at the time of trial? And what I think is very telling is that their trial counsel essentially consented to this all. They did not object to that jury verdict charge as written. They consented to the verdict sheet as well. And when we made motion in limine practice about what would come in about the contract and the indemnification, it was their counsel that says, we shouldn't talk about any of this at trial. That would make no sense. But now on appeal, they want to say, well, we should have been able to talk about it.
Well, the issue on appeal is the summary judgment motion.
Correct.
And do you think you won that?
Absolutely.
Well, how do you, what do you deal with the language in the decision?
Well, so I'll give a little more context here.
Well, no, I mean, we read the decision. We don't need more context. How do you reconcile the language in the decision and the language in the order?
The decision and order. There was clarification that the court did in approximately 2 to 3 weeks. I believe the decision.
You mean in the email?
That, I think that was later on.
Okay, all right.
So if you look at the actual decision order, I believe it's August 27th. It's late August of 2024. And that's when it absolutely says that against Acadia, it is contractual indemnification as a matter of law. There's no conditions on it. The decision that comes, I think it was on August 8th. I could be wrong by a day or two.
Decision comes first.
Correct. The decision comes first. And if you read that paragraph, it says, if Benderson can prove this. And then if you read the rest of the paragraph, it tends to read of all the arguments we made and all the ways that we did prove it at the motion phase. So I understand that there's a little gap there, but as someone who was involved in this case, wrote the motion papers, tried the case, and has done this appeal, there were multiple questions about the court's decision that were then conferenced with the court. An order could not be agreed upon. And then the judge's law clerk, Chuck Sircone, and the judge issued that decision and order that clarified the ruling. And I think what is also imperative here is if the court.
Let's back up just 1 minute. So
Sure.
you would agree that the language in the decision, the August 8th decision, that Benderson's motion for cross motion for contractual indemnification is granted insofar as Benderson can establish a trial. The plaintiff's action against Benderson arises out of Acadia's work. You would agree that that's a question of fact that the court found in the decision.
Well, I don't think so, because if you read the rest of that paragraph, again, I don't have it's a big record, as you well know, so I don't have it in front of me. But if you read the rest of that paragraph, and you read it, and it seems then the court states that, but it did prove it. So that's why the court was asked for clarification, and that's why it issued the decision and order, which is really the final order that's appealed from. So there was clarification on that issue among others.
Well, but on that point, what you're calling the decision and order, which is just labeled order in the record.
Correct.
It's just labeled ordered. It has an ordered paragraph incorporating the August 8th decision.
Yes, but the language is clear, and that was drafted by the court, that it was granting it unconditionally as against Acadia. So I think there was clarification on that specific issue among some other smaller issues, but still incorporated because.
Let me ask this question. Assume, for the sake of argument, that we find there's a question of fact on summary judgment. Assume we do that. What's the relief?
I guess you'd have to have a trial on this issue. That would be
the jury verdict or whatever facts were elucidated. The jury wouldn't, in your opinion, wouldn't be enough to resolve that.
Yeah, and I can get into the facts that I think show it, but I still want to clarify a little bit on this point about you're focusing on what I perceive that you think is some inconsistencies in this decision and order. But what I'll show you that there was not inconsistencies, because what's in the record is directly after that decision and order in late August comes out, plaintiff moves for a motion to renew and re-argue that is heard directly before the trial and is denied. It was never reduced to an order, but those motion to renew papers are in the record on appeal. So if the court felt that there was an inconsistency and said, you know what, we went too far with that order we issued in late August, it had an opportunity on the eve of trial to clarify it. Then, after the trial, in the post-trial motions, Acadia once again tried to make this argument for the third time that post-trial that the court should have never made that decision pre-trial. And again, that ruling was made as part of the final order that was turned into the judgment that brings us here today. So any inconsistency in those 2 August decisions and orders, I think the pattern of the court consistently denying Acadia's arguments and upholding its prior order and agreeing with Benderson shows that, that it was a conditional order. There was no question of fact.
And unconditional.
Yeah, I'm sorry. Thank you. And I think if you go back to analyzing it, they keep on talking about this pothole. We weren't there to fix potholes, but the testimony that was actually elicited by the plaintiff was that this entire parking lot was snow, slush, ice. They keep on trying to harp on, she used water a couple times, but my brief is replete with all the time she used those magic words. And then on page 9 of my brief are the photos of the parking lot. This does not look like some parking lot that's blacktop with a little bit of slush in a pothole. I mean, it looks like an untreated parking lot that we're probably going to be dealing with, this afternoon. And in that you can see there's, footprints, tire prints. It looks like push cart prints. And the owner of Acadia, Mr. Marinaccio, admitted that once he goes to a property, it should never look like that. It should be down to blacktop, and it's, he would never leave it like that. So clearly something was done wrong when they were on property that day, that they didn't, clean it all up. And then there's arguments about, maybe there was additional weather. The fact that appellant makes those arguments in their brief and is citing the testimony that was stricken from the record by Judge Panapinto, I think just shows the weakness on those issues that it clearly comes from this. Unless the court has any other questions, otherwise I'll rely on our brief.
Thank you very much.